Good evening. Welcome to the September 9th, 2019 meeting of the Grafton Planning Board. Is it really September already?
Yeah.
Holy moly.
It's,
First item on our agenda is public input. If anybody is here from the public who wishes to speak on an item that is not already on the board's agenda for tonight, now would be the time to come up to the table or the podium and share your thoughts with the board. Seeing none, we have some action items to deal with. First being the release of bond, request from 100 Milford Road to release a stormwater management system performance bond.
Okay, so these next two, actually three, basically just staff considers them administrative action items. 100 Milford Road, in your packet you had two memos from me regarding inspections at the storage facility. The first was a result of a request for final inspection. I identified 4 items that need to be resolved, 3 of which were trees, 1 of which was some grading, and then there was also just verification from fire department that they had access to the facility. There's a second memo that basically identifies that those items were addressed. The planning board, when we first approved the project, had required $30,000 bond for stormwater. With that project being complete, they've been issued a CO from the building department back last Wednesday. The last item for that is for the release of that stormwater bond. So that you know, that storage facility is being sold. So a different entity is going to be controlling it. Of course, the planning board's approvals still do apply. So, for example, 3 trees that were dead, or 2 that were dead, 1 that was removed that were required to be planted. That same condition going forward, essentially in perpetuity, that will need to be maintained. That realistically is probably the biggest thing that the board was concerned about. So we'll be dealing with the new owners of that storage facility should there be any concerns in the future for that project. So staff recommends that we release that bond that's being held for stormwater for 100 Milford Road.
I suppose a motion would be in order to accomplish that task.
so moved.
Second.
Moved and seconded that the board approve the release of the bond as requested. Discussion on the motion? Hearing none, all in favor?
Aye.
Opposed? Motion carried unanimously. Onwards to Lot 68 Highfields.
Okay, so this is the second item. In the material that was provided to the board, you'll see that there was a request for a lot to be released. This was oversight regarding Highfields, Highfields at Grafton, the development that has 2 phases for housing. There was a lot of lots that have been released. They're all now connected to sewer. This, in looking at the gap, Attorney Antonellis identified that this is a lot that inadvertently was left off the list. It falls in between 2 ranges as far as lots that the board had initially released and then held a bunch, and then when they started with lot 69. So this was inadvertently left off. And staff, because there is adequate bond, recommends the release of lot 68. Should be noted that most likely coming forward over the fall and winter, they're going to be looking for reductions in bond because there has been a lot of construction that has been going on in that second phase. But at this time, they're not proposing any reduction in the bond that is currently being held by the board for that development.
Okay, here again, it seems like a motion might be in order.
So moved.
Second.
Moved and seconded that the board approve the lot release of Lot 68 Highfields at Grafton. Any discussion on the motion? Hearing none, all in favor?
Aye.
Opposed? Declared motion carried unanimously.
Just regarding that item, when the board adjourns and leaves this office, I have this downstairs, so if everyone can come down to sign. everyone needs to sign, except I'm gonna want one person to withhold their signature so that they can come back to town hall to have their signature notarized. For everyone that's familiar with Highfields, usually we have Attorney Antonellis there, and he just does it all right here, but we don't have him tonight, so he understands that one member will just have to come back and have their signature notarized with the town clerk or someone out of the Board of Selectmen's office.
Okay.
Very good. So let's all remember to head downstairs for the paperwork after we adjourn the meeting.
Better remind us then that it's a
Yes.
long time from now.
Yes, that could be quite a while from now. Our last action item, plan
Okay.
endorsement for 155 George Hill Road.
So we have this roll of plans that's right over here. One of the things that was required by our decision was that a final set be developed with the conditions of the board's decision put on it. Staff has reviewed it and identified that it is not only consistent with the final set of plans that the board had approved, but then also has the appropriate conditions on it, and staff recommends endorsement. That again will be something that we do at the end of the evening.
Right, and that does not require a motion, does it?
No, it
I
just,
didn't think
it's
it is. It's just we have to
basically just
sign.
an action.
We have to limber up our signing fingers.
Correct.
How do we end up having to sign plans for that? It's only no, it's not a subdivision.
It's a special permit though.
Yeah. I don't ever remember signing plans, or it's a long time since.
We did for all of our solar projects.
Okay. Okay.
So, and it's one of those things that, along with special permits such as this, we want it to be in perpetuity as far as going forward, and discoverable as far as if the property is sold or something like that. But it's not required like it is for a subdivision. So if the board wanted to say we just wanted to have an overall development plan attached to the decision which is recorded, the board could include that in a decision. The way that we drafted this decision is sort of standard with the other ways that we've dealt it, but it is something that can change. Some towns don't require it. Some have the plans literally attached, so it's an exhibit. Others record it. So,
And this happens to be the way that we did it for this particular special permit, so
correct.
at this point, we have no choice but to perform the signing. Okey dokey. Our next agenda item is a discussion item, pre-submission of special permit application for marijuana establishment at 134 Worcester Street. So, you're up, Bruce.
So I assume you have the PDFs that you can throw up there. So I appreciate the time. I asked the chairman to see if I could have some time before the board before I immerse myself too far in the engineering and survey process for the site. I provided a 12-year-old set of plans, which is kind of a maximized build-out for the two parcels in question. This is not something that we would particularly want to build on the site. This particular plan would be very, very expensive and more room than we actually needed. But it gives you an idea of relatively what the property can yield, especially when it concerns to parking. So what I wanted to do was just come show you what it could look like. We'll probably reduce the size by half the building size and probably do 2 stories. So we may get to 8,000 square feet. We may go subterranean on it and get some basement space as well. But the idea behind this is to create as much parking as possible. There's 2 curb cuts into the state road now, so we'll be able to kind of manage those to mitigate traffic concerns, one way, diagonal parking. But I wanted to kind of put this out there before we did too much, because as you all know, engineering and survey work is quite expensive. And I want to make sure that the board that's going to have direct control over how the end product here is built and designed, et cetera, is I get your input before I go about that. So what I'm trying to do is just collect opinions, thoughts, where you're at on this particular project. It will be the first retail dispensary before the board. And, this is Grafton. Firsts are technically the most difficult ones. So I wanted to make sure that I presented it here. Collected what I can, and then you can send me on my merry way. I know you have a full agenda tonight, and there's a lot of people here for some of your further agenda items, so.
Joe, can you maybe go to the page that has the cuts, shows the contours of the cuts? I was just curious, I didn't get a chance to try to figure it out on my own, but in terms of how much space you can get there, that shows serious cutting into the
Yeah.
the left and the top. And I was wondering what slopes were on that. Did you look to see what slopes those cuts were, as to their realisticness?
They, what on the back of that building to brace it, I mean, that infiltration system there is, and the water management system, that's cost prohibitive.
Yeah,
And you'd have to do a lot of contouring there because it's steep. You're gonna have to route the water, you're gonna have to do a
Right.
lot of work there. That back of that building is basically calls for a 14-foot foundation in the rear right corner where those contours are. We're gonna take the building and shift it to the right, and use a little bit of the 200-foot area. We can do, I believe, 5,000 square feet, or 5% or 10,000 square feet by right, and kind of move everything over so we can put a building off to the right and still utilize a lot of the parking space in front and maybe do some more with an employee lot as well. I know it's hard to visualize, but take that building, shift it to the right, cut it half its size,
yeah.
and
But I was just thinking of the contours that are over on the left. Because all that cutting back there is part of what makes room for parking. And I'm wondering if that's a 3-to-1 slope or a 2-to-1 slope.
I don't know the calcs on the actual slope.
Because, don't we, isn't 3-to-1 required, Joe?
Within here, so this plan never came to the plan.
No, I understand.
I'm just sort of explaining this went through about 4 hearings with conservation, and then they had some final comments, and then the applicant back in 2007 never came back. There's some retaining walls that Bruce was saying that realistically make this very expensive. The grades that you're talking about end up being solely within the subdivision rules and regs. Now, our site plan guidelines do bring in subdivision rules and regulations. However, we are now under new stormwater NIPD's approvals, which require LID. And talking to Bruce, some of this area that would be graded would be best for open air infiltration. So that these grades would not be realized. That 17-foot foundation, essentially they're creating a retaining wall to hold back the slope, which then necessitates that steep grade. And by shifting it forward towards the east or south, because we're in a north-south configuration, you get away from some of those grades into more of a less steep area.
We're gonna stay away from that area altogether.
I was just, thinking about realisticness of the, what that showed you could do.
Yeah.
But I'm not worried about it. Depending on how much, you're not talking about as much floor,
No,
floor
footprint,
area.
we're gonna be somewhere between 3,500 and 4,000 square feet for a base
So that
footprint.
requires how much?
It's
parking?
one space for every 150
Right.
square feet of
Well,
retail.
that's 20 or 30 spaces.
But as you know, most of these places, there'll be some retail, but there's also gonna be
Right.
some vaults, some storage, which then you get into the 1 out of 500. My goal is to have at least 60 spots here, which should triple the amount that's required by the bylaw, but we can grow the site later on as this market develops and you'll get less foot traffic over the next few years. But for the immediate, for, these next at least 3 years, I want sufficient capacity to handle a large volume of people. So,
Have you applied to the CCC yet?
not yet. So that was the other thing I was gonna mention tonight. I've been going to the individual boards as they've been meeting, inviting the boards to the community outreach meeting, which is September 26th. It's a Thursday night, conference room F.
I
We'll be
I
right
was
here.
disappointed because I have to chair 2 meetings in Worcester that night.
Wow, that's,
But
Well,
I may send my,
I can imagine you're probably gonna see plenty of me over the next couple of months anyway, so you get a
but it's good to.
good chance.
It's good to have been there. We went to the one for, up in
Yeah.
Centec Park.
I was on vacation, but unfortunately, they, not many people go to these. So we took the CCC has requirements of which you need to make sure you advertise. So you take a, newspaper ad out like we normally do for legal. That's not quite enough to get people there. I'm assuming, seeing that so many people showed up to the Board of Selectmen meeting, that I'll get a much larger turnout. But in addition to that type of press, going to the boards that are directly involved, and making sure that they know when it's gonna be, they can show up and have a chance. We do this through a special permit process. So the community outreach meeting is kind of redundant, but the community outreach meeting is kind of statutorily required, so we're gonna do both. But most of the stuff you'll see at the community outreach meeting, you guys are gonna vet as we go through this process.
Do you have to have the meeting before you can submit, before you can apply?
It's part of the first phase, so the three
Thank you.
phases of the application process, that has to be completed. I really don't want to, it costs a lot of money to start the process and to apply. I want the survey and engineer work done first, get a good idea of how many employees we're gonna need there, what type of executive staff I'm gonna need. And then we'll put that in a more dynamic package, so we don't have to keep going back to the CCC filling in requirements. So,
Yeah. We only allow 2 retail in the zoning. Is there gonna be a race, because there are 5 letters out now, 5 agreements out now?
there is, I believe MJ's Market, of course, has done their community outreach meeting. That's the only other one that's pursuing this. Nature's Remedy probably has, 9 or 10 different host agreements in different communities. They offloaded one of theirs to Marchetti Industries, as you probably know, maybe 6 or so months ago. It doesn't seem like they have any interest in growing the site. It's a very poor site to have a retail establishment back in Centec. When these things go from a destination to more of an actual retail type of metrics, they're going to need to be in places that are visible, that are normally commuted. So I think that kind of deters people from going back there. Resonate has one, that's the Anzio's property, not Anzio's, but the Hannah's property where Anzio's is now. That doesn't look to be in any state of moving forward as well. So Nature's Remedy is, they already have their 3. So they have one in Air, they've got the one in Millbury, and they have one in Tingsbury.
The 3 applies to medical?
The 3 applies to retail. So the medicinal side doesn't count against your retail dispensaries licenses.
I remember the 3 out in medical, but I don't remember anything like that in rec.
Yeah, you're only allowed 3. You're only allowed the 3.
And are you gonna do medical as well as recreation?
No. No, the medical is still vertically integrated. The cost of entry into that side of the industry is something that's gonna go beyond my capacity at this point. Retail is the side that we feel we can probably backtrack. If my facility in Mendon comes online, we have actual space to do these type of things. But for right now, I just wanna do a retail dispensary there. It's easily controlled, you know what you're doing, and it's according to the law, wholesale goes to retail on the retail market side, so.
So, do you expect to be manufacturing or anywhere, not here, but anywhere, or are you gonna just be buying?
So, grand scheme of things, if the Mendon property bears fruit, so to speak, I have a building that's existing there, and then a lot more developable space. I also have 100 parking spots over there that's very underutilized for what I owned it for. So we have 7,500 square feet of steel building. So, we probably do 2,500 square feet of retail, and then the remaining 5,000, we would either do a micro, which of course includes your processing, delivery, cultivation, all under one, as long as you're under 5,000 square feet of canopy. But we also have the ability to build a building there, and still have ample parking to do everything we want. So if that comes to fruition, we'll probably move those type of processes there. This particular site, it's a main drag, it's 122 and 140. I don't want to mix too much business there with what we're trying to accomplish, which is just have a place for us to sell the cannabis. So in 2 or 3 years, maybe we look for a kitchen, but I really want to see what the impact is there. So as far as I'm concerned, as much parking as possible, let's see how the next 3 years go, and if we don't need that much parking anymore, we'll come back and ask to put more of a building there. So, and then, of course, the host agreements, you never know how that's gonna go. In a couple of years, there may be no more host agreements at all, or I may come back and ask for a manufacturing host agreement. So, just for, if anybody's watching this, the way it's set up is you're allowed to cultivate, and I'm not patronizing them, just for reference. Cultivation, manufacturing, and the actual retail dispensary pieces are like the three main branches of the retail side of the market. So cultivation, of course, is where you grow. Manufacturing is where you take what's you grow and turn it into a product, and then the retail dispensary is the only place that you can actually sell the product. So,
All right, any other questions or comments from the board? Any suggestions?
Just one thing, I don't know whether you saw it whirling around in local social media today, but there was a big fuss about some of the collection boxes along Worcester Street, and
Yeah.
I guess there's one up at
there
your
is
area.
one there, and it's constantly has you name it there,
Right.
from TVs to bed frames to mattresses.
So I said if I had a chance, I'd ask you whether anything, we managed to get the collection boxes at the hopefully forthcoming gas station cleared out.
That's gonna have to go. We're not gonna be able to utilize that site for that type of traffic. So we had a preliminary conversation with the Chief Rapo, and I think one of the things that he's gonna wanna see is that parking lot to be barred after hours when we're not, so we're not gonna have anything
No,
there
I
where
understand
people can
that
go.
then, but I'm talking about now.
Oh, it's gonna have to go before we start doing the demo and the clearing, so.
People would like to see it go tomorrow.
I will work on it as soon as I can. I don't really wanna touch the site until we get
Okay.
people on it, and then we're gonna go in, and we're just gonna clear it out, improve the sight lines for getting it out, so when we go to delineate the wetlands, and we do some more follow-up survey work, we can, get a nice look at the place. We're gonna do some water samples too, some soil samples, et cetera, see where the water table's at, and, go through the standard motions.
Okay.
So my only question on this is if you're doing it 2 or 3 stories, if you count the basement, is it the retail only gonna be on the one main story of the ground floor?
The CCC is pretty strict in how we're gonna have a layout. What I wanna make sure is, I don't know if you've been in the facility over in Millbury. So they have a nice floor space. You really can't have windows on the first floor. So, you can, but they're very hard to navigate. So we'll have a very closed off first floor. Having a second floor with some loft to it, means you can have some skylights up there and things of that nature to let some natural light in, so it's not as claustrophobic. And it also gives us the opportunity to put some office space on the second floor that executive staff can use. A basement level, I think, is just gonna, if you follow the contours of the property, it kind of makes sense to put a basement level in, which we could use for a lower level for employee parking, some of the delivery things that can go on back there. And then we can have a little extra square footage for whatever the need might be. But that probably would have nothing to do with the actual floor space for the dispensary.
Okay.
So, we can store lawn equipment, and you can do other things like that in that space. And then, of course, we'll have more than ample parking space for the entire thing, so.
I have two questions, Mr. Spinney. One is this primarily being planned for retail, is that what you said, or is that also growth at this point
No,
of
just retail.
retail? And retail would be both the manufacturing, no,
No, they're separate license tracks, so the manufacturing would be a separate host agreement, would be a separate license with the state. This is just purely for a retail shop,
okay.
so.
And the second one is, do you anticipate large delivery trucks out here, and would that need to come through some path, or?
No, most of the product and the cash that will probably leave the facility will be smaller trucks, 16-foot box trucks and armored transports and things of that nature. We'll have, on this plan, we have a delivery and loading area. We're not gonna use that. We're gonna shift the building over. So we'll probably have its own separate area for navigating the larger trucks to get back there. So, but no 18-wheelers, you shouldn't see anything large. During the construction phase, yes, you might get a lot of lumber and things dropped
During
off on
operation
big.
as well.
Yeah.
Okay. The last question is, I asked a similar question when the other facility of Depot Street was up for discussion. Is this, from a security perspective, is this something being vetted or worked with the police department? Do
Yes.
they have a say in it? I just do,
They,
the gentleman who came and said that mine would be better, and I hope that's not the answer.
no, it's, so the CCC's requirements are gonna dictate what I can do for security measures at a bare minimum.
Okay.
In extension to those type of things, like for example, barring the street access during off hours, that's not something that the CCC is gonna require. But we'll do it just because the chief wants us to do it. So in this particular situation, it's a little different from a lot of these because I live in town, I travel that road every day, and I live with everybody around me. So I, of course, am willing, as long as it's not something that's gonna get in the way of another security feature that needs to be in place. One of the things that's primary in here is not so much to keep people from breaking in, it's from people taking stuff out. And that's the primary motivator to making sure everywhere in here is covered by CCTV. And we'll extend that to cover all the parking lots and every egress that's there too. So everything there is gonna be covered. It's a nice, secure spot because you have the Quinsig behind it. There's no real opportunity to get to it from the rear. The Mass Pike is on the northbound side of the property, which is a nice artificial buffer. And then next to it, of course, is that smaller chiropractic center, which will be able to provide some buffer. And there's plenty of room between the parking lot and the street that we can provide some good natural tree cover and some buffering to make sure it's as little intrusiveness into the neighborhood as possible.
Okay.
So,
Thank you.
So just a reminder for the board, there are about 7 provisions within Article Section 5, 5.10.8, findings that basically require documentation that the applicant submits that the board is able to consider. In addition, it's going to trigger a requirement for a traffic study consistent with Section 8 of the bylaw. Findings and documents required under 1.3.3 site plan review, as well as findings the board needs to make under 1.5.5. So compared to other applications, the board is quite versed in requirements for site plan, special permit, as well as traffic. Within the marijuana establishment bylaw, we bring in about 6 additional criteria for the board to consider, and I've already been communicating these items with Mr. Spinney.
what we'll try to do is have everything done up front, and then when we hit the public hearing process, we make it as painless as possible, for people to get the information, make sure it's readily accessible for everybody. And we'll try to outline it as best we can to make people understand the process. But our bylaw mirrors what the CCC requires, so there's a lot of redundancy here, which we have to do anyways. So the key would be that in the site plan review, no waivers, we're trying not to look for anything special in this particular place, so we can move through the process. So,
I'm glad that you came in. I've always, you probably know, I've always encouraged people, the idea that people should come in and talk to us before they get
Yeah.
down the road, where it's hard to make a turn when they get here.
well, it's bewildering when you fill up a room. We all served, and, I was on planning board with you for, 4 or 5 years, a while back. And it's tough to see applicants come in and struggle when they hit a public hearing process where we could avoid a lot of the pitfalls by just having a nice casual conversation before we start the
Right,
process.
that's exactly
So,
my point.
so we'll provide something that's, very rational, very economical for us, and make sure we take, safety and traffic concerns as a paramount feature of the build-out. So,
Yeah, I suspect that one of the biggest concerns with this site is going to be, one of the most frequently asked questions is probably going to be about traffic.
The problem is any business that goes in there is going to increase traffic.
yeah,
It doesn't make any difference.
Yeah,
If the business is going to be successful,
Yeah.
it's going to have traffic.
Yeah. I'm sure people still remember the first days of Leicester, and
Yeah.
I think we're long past that. Even Lester's, last I know, that was only a fairly short-term surge in traffic, and now most locations around that are open are pretty, have kind of going back to arguably
It's starting
whatever
to
normal
normalize.
exactly is for this, but.
You'll see it this, so you're surrounded by a few no communities, Westboro, Upton, Northbridge is not gonna be anywhere close to this, so you see a lot of the through traffic that you get going to the Pike and things of that nature utilizing this facility. But you have really good sight lines, that far up, and you have 2 curb cuts already, so we can play with the traffic study and the design of this. One way is probably what we would have to do to make this, it will have a minimal impact. With the amount of spaces we have there, you'll see a bump for the first 2 days, as all these are, and then they'll normalize, so.
Yep, and I don't think I've heard any other sort of major question. I mean, the questions Bob was raising initially about the site layout and the grading, and we all understand this plan does not very well represent what you intend to do, and you've talked about that, so I think, you've got a pretty good sense of, how this board would probably be looking for a much less of an impact on the topography.
Well, and yeah, and just financially speaking, what's up there is incredibly expensive.
Yeah, you wouldn't want to
So,
do that anyway, just from the cost of construction.
But what I wanted to get is give you an idea of what the
Yeah.
what the site can bear, and then parking out in front, building in back, those type of things is what I want to make you aware of. So there's no huge changes to how we're laying this out. We're gonna fiddle with the building, we're gonna fiddle with the parking lot, and
And I'm
of that nature.
pretty pleased with the idea that the site gives you the ability to provide much more parking than the minimum that our bylaw requires.
it's deceptive there too. I mean, we all know it's been a boarded up building for a decade.
Yeah.
It's kind of an eyesore now. We want to just get the thing knocked down and start working. So
We've been waiting for many years to see something happen here.
we'll do something very aesthetically pleasing too. I mean, our goal is to build something that doesn't stand out. We just want a retail shop, so to speak. And you guys control the signs there anyways. You know that this is not going to be anything that's too elaborate and gaudy. So, I mean, I'll ask for a 100-foot sign just so you can see everything from the Mass Pike, but
Yeah.
I'm not sure if you guys are going to give that to me.
Yeah,
So,
the CCC kind of limits what you're allowed to do for signage and advertising.
yeah. And so, unless there's anything more, I'll let you get on with the rest of your show
Anything else from the
tonight.
board?
Thank you.
Again,
Thank you very
I'll
much.
add my thanks to you to coming in and having this
Thank you
discussion.
for having me. And remember, September 26th, Thursday night in this room. We're also going to tape it, so we can
Outstanding.
make sure that we disseminate it to as many people as possible in town. They can't make it that evening.
You're gonna tape it yourself?
I asked for public access to come
Okay.
and do it for me. See, and that's why I wanted to put in this room so I could have a professional do it. So maybe Billy will do it for me, or but I went to Bob DeToma and asked if he had that night available, if we can make something work,
Right.
so we could do everything in here. So,
That'll help me because
well, that's
when
right.
I come back from Worcester, I can see it.
Yeah, and it'll overlap on some of the concerns you're probably gonna have during the special permit process. The more
Oh,
people
yeah.
know, the better it will be for this process to go through. So,
Great.
thank you,
Sounds
guys.
good, thank you.
Thank you for
Thank
your
you.
time.
All right, the time is now slightly past 7:30, so it would be in order to begin our public hearing, this one being the continuation of the public hearing for special permit SP 2019-A/SPA site plan approval, 84 Snow Road rear and 23 side Greeny Drive, Crown Castle Towers, etc. So let's get everybody in place for this.
Watch out behind you.
I believe we have here on behalf of the town, in addition to the board and staff, we have David Maxon, our wireless consultant, and our additional, if you would introduce yourself, please?
Sure. Hello, everyone. My name is Chris Heap. I'm an attorney with Miaris and Harrington in Wellesley, and I've been brought on to help assist the board in its review of this application.
Okay, so I'm trying to remember, I think where we left off was the board's desire to engage outside counsel in the person of, I'm terrible at remembering names, Chris Heap?
Chris Heap, yes.
So, one of,
And, you know, go ahead,
one of the
go ahead, Joe.
questions, you know, for chair and the board is, the request, for assistance, you know, was passed on to town council. Town council recommended we seek outside counsel. By the time we got to the board of selectmen, you know, a period of time had gone by, and the applicant graciously granted a request I made to extend the public hearing to tonight to allow for Attorney Heap to get up to speed onto where we are with this application. The applicant has submitted some revised documentation, but then we also have, you know, Attorney Heap providing his review of the application and what's before the board. Unfortunately, didn't have a time to try to coordinate with you as far as what we want to take first. See whether or not we want to discuss the application or hear some of the testimony first. So would probably recommend to the board, you know, decide which way we want to proceed, at least initially. Attorney Heap's letter is up on the website as Exhibit 43, so that people, if they had taken a look, and planning board members, I don't know if you had a chance to take a look, you want to review that as one of the first steps.
Gotta be
Oh,
careful,
yeah.
because I messed up your name last time. Victor?
Victor Manugian.
Yes.
Maybe I can do an end run. Unfortunately, I'm here to report that Jason Mayo, who's my program manager for strategic acquisition real estate from Crown Castle, conflicted out, couldn't make it tonight. So without even going into anything today, I would request that we continue to October 14th so he could be here. I did have a chance to talk with your attorney, Chris Heap, and I know where he was going to come from. I will say that I didn't see the, I looked Friday late, and I didn't see the, I'll say the two lawyer letters. I saw them today, which is in addition to Chris's, Scott Regan's on behalf of American Tower. And both have raised issues that I need my client here for. So as Joe said, I agreed to continue today because your counsel needed time. If you remember the first meeting, David Maxim couldn't be here, so I agreed to hold off with our experts, brought them back. So I'm just asking for one courtesy back to continue to
Yeah,
October 14th.
so you would, yeah, you're looking for some time to review and respond to the,
The two letters and
Two
the-
letters
the
that
topics
just
raised,
submitted.
and have Jason here with me.
Yeah.
After, it was quick to review those, seeing them on the site today.
Well, I think that we have a good many people here who are interested in this, and we have two consultants, and it might be well to at least let people hear, you know, I don't think, I was watching the website, and the letter wasn't up there until quite recently, so I'm sure that hardly anybody knows what advice we got on that. So it might be helpful for folks, and for the progress of this thing, to maybe touch on a few of those things
yes.
before we.
So you're thinking sort of a brief kind of review or a summary of what has just been submitted?
And then see,
Yeah, without getting too deep into it, because, you know, Victor and his client would like some time to review those letters and respond. And I'm certainly willing to give them the time they need, as, you know, as in general, I like to make sure that everybody has the time they need to review the materials and everything. I would also just ask if, just very briefly, what the changes were in the revised drawings, without trying to drive it too deep into discussion, but I haven't had a chance to review them yet. So just a brief summary of what's changed, and a brief summary of the recent letters, and, you know, without a whole lot of discussion.
but also I want to know where this would put us on the shot clock.
Good question.
As I'm quite concerned that we are pushing this out too far.
I believe it was mid-October. I forget the precise date.
I filed May 28th, so 150 days would be about the end of October. The 14th would be before that date.
Yeah, but it takes us a substantial amount of time to prepare a decision and act on it. So I don't think we're gonna have time,
So,
unless there's some way to extend the shot clock. And the way I hear it, that's difficult.
I would typically, I'm new to this board, but I would typically, where the applicant has requested an extension of 3 weeks or 4 weeks, I would typically ask for an additional extension of time on the shot clock for
That
the
is
board to
possible.
conduct its public hearing. That is certainly possible as long as the applicant agrees to it in writing.
Okay, because I am not a fan of hearings that go on for 6 months.
just for the board, application submitted May 29th, stamped in June 4th, public hearings on July 8th, July 22nd, August 26th with no testimony, and then tonight. 150-day shot clock from the May 29th would be Saturday, the 26th. So whether it's October 25th or October 28th, that's where we're right at the end. So because of town meeting, we don't
Yeah.
follow the second and fourth Monday. So then we would be looking, we have because we've already established our September schedule. We're looking at October 7th, and then the follow-up meeting would be October 28th. And again, that's because of Columbus Day, the 14th, and town meeting on the 21st. So as we look at dates and all those things, as far as what works for everyone, I just want to make sure that, you know, we have down that 7th and 28th.
Okay. Oh, are we gonna hear from anybody from American Tower tonight?
Yes, sir, I was gonna ask to have a moment to address. Good afternoon, I'll try to keep this as brief as possible. I understand this thing has been going on for a long time. My firm.
Introduce yourself.
Sorry, I'm Scott Regan on behalf of New Towers LLC, and here with me is Kelly Shea.
Hi, I'm in-house counsel for American Tower, so I'd be happy to answer any American Tower.
We need you as close to the mic as we can get you.
Sorry.
And there's also a podium too,
Yeah.
if that's easier for you guys.
Sorry.
Wherever
Is here
you
good?
want
Can
me.
you hear me okay?
Yeah, we want to make sure that the folks who watch this on television can hear you, though. And
Okay.
so,
What's easier for you
why
guys?
don't one of you use that, and one of you use the chair?
All right.
Okay.
Good evening, everyone. As an initial matter, we would oppose the request for a continuance. This thing has been going on for some time, and my firm sent a letter to special counsel, and basically we outlined the legal and factual arguments that we contend should have been addressed before this application was filed in the first place. The law relative to seeking the special permits has been the same for a long time, and we made it very clear that basically, you know, they filed this thing without trying to work out the economic hardship that they contend. Crown Castle is a multi-billion-dollar company. Our clients have had a relationship for a number of years, with each owning, you know, easements under each other's assets nationwide. And this has already been continued to a date of Crown Castle's choosing. It should be denied.
Does American operate towers the way they do?
So actually, our clients have had a relationship for a long time, and yes, there are various American Tower assets nationwide where Crown Castle owns easements underneath. So we're essentially looking at a landlord-tenant relationship, and if one party is unhappy with the economic terms of that relationship, I think it's incumbent on them, and I think the case law supports my argument, that it's their duty to try to work that out. That did not happen here. Before filing the application, I think the law is pretty clear that they should have reached out to us to discuss it. They didn't, and we have since made efforts to resolve this thing without additional need for town resources. And my understanding too is you know, Grafton has actually dealt with these things in the past and has denied these types of special permits for basically less evidence than has been submitted by Crown Castle here.
I was there, so I've been here for all of them.
Bob would know.
The two
I would know.
is-
What I'm interested in is whether, should they run out their lease and leave, what are the prospects for still having service from the Indian Path site by some other means?
I can't get too much into detail about the settlement communications. I can tell you with confidence, my client has no intention whatsoever of terminating the lease. They're very happy with it. It's a relationship that's worked nationwide for a long time.
But if, you know, they've said that their lease is up at a certain, you know, next year, and if they leave, you know, if they don't renew, then is there a prospect of, because apparently there'll still be a special permit active at Indian Path that would allow a tower.
Yep, so we have no intention of terminating any lease with Crown Castle at this site at all, and we'd like for them to remain on this parcel as they are. But if they were to terminate, which we would advise against, of course, we'd entertain taking assignment of that tower if the opportunity presents itself, so that we can maintain continued coverage for the Grafton area. We understand that cell towers are essential to modern society, so American Tower really has no intention of taking that coverage away from the community and all the residents, so. But once again, we don't own this tower right now, we are just the land, we own the easement. So if that, in the future, that opportunity presents itself, we'd obviously entertain that opportunity, but we're not really at that point yet, and we'd like to work out some type of deal with Crown Castle at this parcel, so that's where we stand right now for that.
Okay, Mr. Maxon, I think you would.
Thank you, Mr. Chairman. David Maxon with Isotrope. I wrote a report after looking at public records on this site, and I've heard a couple of times now a reference to the lease, and I believe that we're talking about the lease between American Tower, which controls the easement underneath the Crown Castle Tower, and Crown Castle, which owns the tower. According to those records, I also have come to the belief that there are wireless carriers who are renting ground directly from American Tower. Is that correct?
I can't speak to exactly if a carrier is rented from us, but generally how those type of sites work is that there are ground lease, like for shelter spaces, sometimes carriers will rent from the parcel owner or whoever owns the easement, but I don't exactly know the terms of which carrier has which ground rights with us there, so. But generally, there's rental spaces on the tower, and there's rental spaces on the ground to support the equipment that's on the tower. However, without me looking at the file, I can't speak to specifics.
All right, Mr. Chairman, just to remind you and the board what I said in my report is that there are a couple of companies that have filed notices of lease of the ground space with the American Tower, the party that controls the easement. So they have leases with American Tower. It is not just Crown Castle that has a lease with American Tower. And that means that in the worst case, Crown Castle and American Tower can't come to terms, and Crown Castle decides to pack up its toys and take them away, in other words, remove its tower. There are still tenants on American Tower property that could enjoy a tower of their own or a tower of American Tower's construction. It could be messy, but it would not result in the end in a prohibition or effective prohibition of the provision of wireless service at that site, because American Tower has indicated that it is doing whatever it possibly can to keep its tenants at the site. So I just reiterate what I said in my report, which is the prediction that there will be a significant gap in service and there needs to be a tower on an adjacent property to solve that significant gap, in my mind, stretches credibility.
Any other questions for the American Tower representatives?
I have one question. So, going back to our consultant's point, so the way I understood this is a multi-party contractual agreement. Can that still be broken off between Crown Castle and American Towers? If they decide, hypothetically speaking, if they break the contract, if they agree to void the contract, would the other carriers who have a contract with them, would they not also need to be part of this agreement to say yea or nay?
My understanding from the evidence on the record is that it's not a multi-party contractual agreement.
Okay.
Is that when AT&T first acquired the site, it leased ground space from the landowner and built a tower. AT&T sold its tower to a tower company, which ultimately ended up in the hands of Crown Castle. When additional carriers came on the site over the years, they rented ground space from the property owner, and they rented tower space from AT&T / whoever became the tower owner. So those other carriers have two leases, independent leases. And that's why even if the tower goes away, these other carriers, according to public records, have leases with American Tower for the ground space. They still have the right to be there. They just would need to come up with a new tower if the existing tower comes down.
Okay. Not to get into too much of legalese here, but would Crown Castle not have it as part of their agreement that these carriers whom they have leased out space on the tower, and that is by virtue of that lease is what they would get to lease something on the property. So all I'm trying to understand here is it as clean as if these two parties come to an agreement and say, okay, we can void this contract and we move away, is it going to be as clean as that? Or would the carriers also need to be part of this agreement at any shape or form? Do we have enough inputs about that?
I think that's certainly a question for the legal folks, from someone who has negotiated leases both as a tenant and a landlord for radio communications facilities. It's a tenant-subtenant kind of relationship. So the tenant has the deal with the property owner, and then has subtenants on his tower. So what goes on at that upper level of the agreement is between the tenant and the landlord. And the subtenants usually have the right to perhaps look at a change in landlord-tenant relationship, but don't have any say over it.
Okay.
But again, I don't want to get into interpreting these particular deals or anything like that, but in my experience, that's what we see.
Generally speaking.
Yeah.
And I won't get into the legalese anyways, you can all read it in my letter. But just a reminder, we're here based on Crown Capital's application that there's an economic infeasibility. And the law does require that they explore every viable alternative in order to show that they're entitled to a special permit. My client has said repeatedly that we're willing to work with them to make this thing work. We don't want the tower to go away. We don't want Grafton to lose wireless service. And as of right now, there is no risk of that happening. None.
That's what's bothered me all along. At the first hearing, I asked about, we need to understand the economic imperative, and I asked for information, and I followed that up the next time. And each time I've been told that they won't give us any. And then, but they've said that there is an economic imperative. And then we get the letter from you folks that says they've never talked to us.
Right.
That creates a problem for me.
All right, Victor, you wanted to
I
say
just want to
something?
comment on the question you raised and the special permit and the tower. And I talked about this with your counsel, Chris, briefly, and he said he'd think about it. So our position is, and I don't know if David's right, I don't know if the carriers have ground leases with American Tower, I wouldn't know that. My client wouldn't probably know that. But I can tell you that we own the tower. That tower had special permits for different carriers to be on it. When September 2020 comes, and we take down that tower because we can't agree with them still, there's no special permits left for those carriers to attach to a tower because the tower is gone. Those special permits talk about that tower, that metal, that level, and that size antennas and all that. So I believe, unless I'm wrong, that there would be interruption of service if it gets to that point, because if we take the tower down, then they're not going anywhere until they file a new application for the land that they have a lease on. I can't argue with that they can do that. But I don't think that just because there was already 4 special permits or how many assigned to carriers, that they can just tomorrow put up a new tower. They'd have to go back through here, come in with designs, tower height, composite material, whatever they're gonna do. So that's my opinion, and I'll defer to your counsel on that. But, and again, I don't wanna get into too much, because my client's not here to answer some of the things he's raising.
The original permit, we were told, was granted to AT&T. I'm not aware of transfer, of us being involved in any way when it moved to other ownership. So I'm not sure that your argument doesn't come up there, too.
And you wouldn't. These things get sold in the industry through, but that's still, those special permits relate back to that tower that was built. And if that tower is gone, I don't think there's special permits left. They have to get new special permits for a new tower.
Well, I suppose I should let those folks over there tell us about that.
Yeah, go ahead.
I'm after you.
Go ahead.
So I was just gonna briefly, if I could, just walk through the comments that I provided in the letter earlier today. As I said earlier, I was brought in to review this application from a legal perspective. I've done that. I've reviewed all the application materials and primarily attempted to evaluate the applicant's claim that there's an economic hardship here that would entitle it to some benefit or preferential treatment under the Federal Telecommunications Act. Part of the applicant's argument in the application materials is that there's a new FCC declaratory ruling that went into effect earlier this year, which allows applicants to rule out potential sites based on excessive cost. There's a lot of stuff in that new FCC declaratory ruling, but in terms of costs, the ruling is primarily concerned with local fees and charges that the town can charge telecommunications applicants for applications for access to the right-of-way. There's nothing in the declaratory ruling that directly supports the position that the applicant can rule out sites based on private rents being too high. So there's nothing in that declaratory ruling that I think directly supports the argument that's been presented in the application, is point number one. But point number two is, and perhaps more importantly, there's no information in the record that would allow the board to independently analyze this claim that there's an economic hardship here. The applicant has asserted in the application materials that there's an economic hardship and there's some economic uncertainty with respect to the site, given the relationship with its landlord/competitor, American Tower. But there's no information that would allow you to determine that there is actually an economic hardship here. And I don't believe there's anything contained in the Telecommunications Act that requires you to take that representation from the applicant on its face, or accept that on faith. So if they're going to well and truly make an economic hardship argument, they've got to support it factually in the record, so that you can make a determination that this site is indeed economically not feasible. And I don't believe that has happened here. And I think on that basis as well, they haven't proven entitlement to any kind of relief under the Telecommunications Act. And so I think, as with all telecommunications applications that the board is reviewing, the board has the ability to require the applicant to investigate alternative sites and go to sites that are better under your zoning bylaw than the one that they've first selected. This application is interesting in that the alternate site already exists. It's already up and running. There's already a tower there. And I think the board would be well within its rights to expect the applicant to do everything in its power to remain remain at 20 Indian Path with its tower and the carriers who are currently being serviced there. So I think not much additional else for me tonight, but again, based on my review, I don't believe on the record before the board there's been a showing that a denial of this application would be an effective prohibition of wireless services under the Act. And I don't believe the applicant has made out a case for any, entitlement to any relief under the TCA.
Question. I'm not clear who the FCC's rule protects. Does it protect the service providers? Does it protect the tower owner? Does it protect the land the land controller?
The FCC's, the Telecommunications Act is intended to allow carriers to fill out gaps in service.
Exactly.
And in this case, so I think the answer to your question is carriers.
And thus far, I've seen nothing from any of the carriers.
No, that's absolutely correct. And I know David has made that point
Right.
to the board
Sure.
before. And I absolutely agree that this application is the claim that there's going to be an effective prohibition, which is the applicant's claim, is hurt by the absence of any carrier present in the room or making actual statements in the application materials. I would expect, I think that they need that as part of their application.
Yeah, it appears to me that there is currently no gap in coverage. There is the potential of a gap that's at issue here, but there is no current gap in coverage. And the likelihood of that potential gap becoming reality is at best unknown. The applicant is suggesting and claiming that the gap will materialize or is very likely to materialize, but as you've pointed out, I don't think there's anything in the record that really supports that other than the applicant's assertions. And so I mean, it's sort of it's two closely related problems that I'm seeing with this. One is the fact that there is no gap now, and the other is the fact that the record doesn't really demonstrate that the gap is likely to materialize.
And I think that point has been made by American Tower in their letter and in their appearance this evening as well. The statement from the landlord that they're here and willing to work with the applicant/tenant to continue this 20 Indian Path as a viable site is, I think, an important point.
Now, if I want to be, sort of giving the applicant the benefit of the doubt here, I would say that the application is here before the board in anticipation of the possibility that an agreement ultimately does not get reached. And so that's a very different scenario from we have a gap that we need to fill right now.
In addition to all of that, though, for me, there is another problem. That is, they need a waiver, which I can't possibly grant. They're now going to be less than the tower height from one of the property lines, and we require 300 feet. They're going to be 73. I don't see that, I'm only one vote on the waiver, but done a lot of waivers or I've decided a lot of waivers on a lot of things. So I think that is also I think they need to find another answer.
So I do have if you want to respond to him, I'll let you speak.
Oh, no, go ahead.
Right. So just the overall thoughts for me is that, at most hearings, we've asked for more documentation about what is actually the financial hardship in writing and what's actually that, and we haven't received anything. We have also brought up at least once or twice on something from a carrier saying that, yes, they will move with you. They will populate the tower when it moves. Or some clause redacted or not with another lease document saying that they have to move with you. Something that says that you'll have a guaranteed carrier at the new location. The other thing that struck me in looking at things is where one of your people, I'm sorry, I don't remember who it was that spoke, but was talking about how the monopoles never fall. And in our records, we have someone that pointed out a few cases that's happened. And, where, I didn't mention to move it, off is one of my thoughts about within the houses, but even still, having a tower that would fall, even if it stays right at its focal point where it's held up and goes off the property line, that's a little bit troubling to me. So those are just my thoughts offhand right now.
Thank you, Mr. Chairman. I don't want to address anything raised because I'm still hoping to get an answer on our request to continue. I listened to what Joe said, that the shot clock runs out October 26th. I will extend the shot clock 30 days from October 26th so that we can come back on October 28th and still have time for you to issue a decision without violating the shot clock.
I'm not comfortable with that much time. I'm relatively conservative. I know that it takes that'll take us across Thanksgiving in terms of trying to prepare a decision and get results, even if everything closes out on the night that you're talking about.
What time would you want for an extension of the shot clock beyond the 30 days?
Well, certainly at least 60 days. But I'm not at all sure that this is going to be productive.
Well, that's why I'm asking, because I'm not
what additional
opening anything
I
up.
mean, having your client here is one thing. Offering additional information that we've looked for and that you haven't provided, what are you going to provide for us at that time?
There's emails attached to the attorney's letter that I saw today that I want my client to look at and give me answers about, where they say they communicated. I want to know what happened at my end. I don't have those answers right now.
All I know is that when we left here, there was an agreement, there was an offer from American, and I thought there was an agreement to work with them from Crown.
Again,
And
he's
now
not,
here we are.
he's not here, so I can't go there.
Well,
Can I add about that? Just about the
Yes.
email he's referring to? So I actually followed up with one of our VPs, who's actually the one that sent that to Crown Castle. I followed up with her today, and she confirmed that there still has been no offer made by Crown Castle, even though we followed up several times. So we're still open to entertaining any type of offer that Crown Castle would provide. But I followed up with her today specifically, before this hearing, so that I could say that.
because the letter or the documents that you sent showed at least two efforts to raise a response from Crown, and apparently you have maybe even more, and you haven't received any. So what we talked about at the last time we talked about this, which was how many weeks ago when we talked about it? Was that July 8th? 2 months ago?
That was July 22nd.
No, was 22nd the one that was continued? No. Okay, the 22nd. Anyway, 6 weeks. Unless you can tell me that we're going to get some financial justification and that we're going to see applications from carriers, I don't see the viability of continuing.
I can't speak to applications with carriers right now, but I was just told that they will continue with discussions, and I can go 60 days on the shot clock. And that way, one more hearing.
No, I asked for justification for your claim of economic hardship, that you said at the first, I think it was the first one, that you folks said you couldn't, that there was no way, that you were not going to be able to find a solution on the current site. there was a question asked and answered as I recall. Certainly that the impression has been that you simply were unable to do that, and therefore you needed to do this new site. Okay.
I think, what is it, Joe, you said if we were looking to, if we were looking to grant the applicant's request for continuance, would October 7th have been, he mentioned the 14th, but we don't have a meeting on the 14th. We do have a meeting on the 7th. Would that be a likely date that we can do this?
It's possible. We do have, it would be another late night. They did just add, when they mentioned about adding a 60-day about meeting on the 28th. We don't currently have anything scheduled for the 28th.
That might be. Yeah, I think in any case, though, in terms of what we've discussed so far tonight, I think we would be looking for some forward progress. The issue that Bob raised about the location and the waivers required for that we've discussed before. That hasn't changed. It's still a concern. On the issue of the potential gap in coverage and the economic hardship argument, those related arguments, there is at least the opportunity for some forward progress, either through Crown Castle and American Tower making some progress in negotiations, or reaching a definitive conclusion that the negotiations will not be successful, and that would have to be sort of, I think, supported by both parties. Or I lost my train of thought. But basically, in a nutshell, what I'd be looking for if we were to continue was a reason to believe that some forward progress could be made on these on the issues of the gap in coverage and the possible alternative resolutions for that. If there's no reason to think that we're going to get, over the next however many weeks, let's say October 28th, between now and then, if we're not likely to see any resolution of these issues, there's not much to be gained by continuing, because based on the information we have at hand on the record right now, I think that likely leads to one conclusion.
Yes.
Additional information that could change that, would be worth waiting for.
And if we don't have it, then your decision's done right there. So I agree to do that. I will go with my client on both those points. Given
So if we were to do that, and again, this is still a hypothetical at this point, but if we were to continue this proceeding to October 28th, we will be looking for additional information to support your case. And if by that time nothing more is forthcoming, I think we would conclude that there is really no more progress that can reasonably be expected.
May I just add one more thing? I'm sorry I keep interjecting. But it seems that the continuance is so they can provide more information about the economic feasibility of the site. However, we've made it known from the start that we want to work with Crown Castle, so I find it hard to believe that if it were continued, they'd have any evidence that would say we're unwilling to work with them, when we've made it clear from the start that we do want to work with them. So a continuance almost seems unnecessary when we made it clear from the start that there's no evidence to produce, because we do want to work with them to figure something out that benefits both parties here.
That's my point. If I don't have a commitment to provide economic justification, if I don't have a commitment to provide that at the next meeting, I'm not going to vote for a next meeting.
I'm making that commitment, and I will tell
To
my
provide
client
the
that's what they have
economic
to do.
justification that you've told us twice you can't give us?
But
Is that what you're saying?
Something numbers-wise.
No.
I hear you, and I hear what Chris has said.
no, but I think American Tower, and I'm sorry, I forget your name, just
My name's Kelly Shea.
made a very good point, which is in terms of the board's overall preference in terms of how this application will ultimately be decided. I think you're not just asking for evidence of economic hardship. I think you're sending the applicant off with instructions that it really ought to go off and get a deal done with Crown Castle. Because we would like that to.
Yeah, let me put it a little bit more explicitly. In my view, based on what's currently on the record, there's no demonstrated gap in coverage. There's no demonstrated economic hardship. And without further evidence, that line of thinking, those facts pretty much lead to a denial of the application. So yes, unless we receive information that changes those facts, the outcome is, at this point, the outcome seems to me to be pretty clear.
I'm interested in whether any of the other members have any difficulty with the waiver. Because if we understood that, we might know how this is gonna come out no matter what.
I have a lot of trouble with the waiver. I think that we actually have a pretty good picture of what's been going on. And that the fact that the two parties aren't communicating, that there's a willingness on one side, but there's been no evidence that, that the applicant has even tried to reach out. So how can they say that there's an economic problem when they don't know what that economic problem is? They can't demonstrate it because they've never interacted with them to know what the economic situation is. So how suddenly are we going to come up with something magic when they've known that and known our stance?
Well, consider Bob's question too. Should the gap and related questions be adequately addressed to support this, there is still the problem of the specific location and the fact that on the subject property, there is no location for the tower that does not require a fairly substantial waiver.
Exactly.
So putting the other arguments aside, which is, I think, the question you're asking, Bob.
Right.
Putting the other arguments aside, could we, as a board, conceivably,
Even grant the,
4 out of 5 of us, I suppose actually, to be precise, the granting of a waiver requires just a majority vote, but the permit as a whole requires a supermajority, and it sort of.
The question is whether there's anybody besides me who is unwilling to grant the waiver.
I'm,
If there is, you're not, Linda, you're not
No.
willing to grant the waiver?
No.
I think the question is clear then.
I don't see any reason to extend it for another 2 months.
And I will say, I am very borderline on even considering doing the waiver, but that, I haven't considered that part of it too hard because the financial hardship reason is so strongly
Yeah.
Yeah.
holding me.
But
But-
like I say, even,
Yeah.
if you set that aside, assuming that, although it hasn't been demonstrated up to now, assuming that the need for this tower is demonstrated,
This site is not.
would such a need motivate us to grant the waiver?
Yeah, I don't think it
And
would.
I lean towards, I'm not fond of a waiver. We have granted some waivers similar to this, but not to the, we've discussed this before, so I don't want to go over it again, but, we've seen other cases where there have been somewhat similar waivers, but not, trying to look for the right word, not the magnitude of the waiver.
Right.
That we'd be forced to look at here.
Can I just comment on that?
Well, let me finish. Also, when the Indian Path Tower got a waiver, it was a very different situation. There was a gap in coverage. This was original build-out of coverage. So there was a clear gap, and their waiver is over the turnpike easement mostly, which is a different situation from private property in a case where we have no evidence at this point. we could get the closure here and save everybody a lot of time.
I just want to comment, I'm trying to stay away from the facts because I'm trying to get the continuance, but I did pull out, Mr. Hassinger had raised that probably both meetings, what waivers were given. So right now, we reconfigured the tower so that it's going to be set back the required distances from residences, but we do need the waiver for 300 feet from property lines. And I did pull out the plans from 20 Indian Path, and Mr. Hassinger correctly said that currently my monopole will be set back 3 distances, 143, 154, and 177. So I pulled out the plans. In 20 Indian Path was 150 feet from the property line of the town of Grafton. It was 150 feet from the property of Lennis and Roscoe Bicknell at 40, that's their mailing address, 40 Carroll Road, but they abut it. And then over by where the house is that the property is that owns this land, there's a 20-foot waiver. It's about 280 feet away from the property line. So he did give some waivers, not as much.
I
but he
need to
did.
see that plan.
I have it right.
You mentioned some numbers. This plan shows 73 feet.
The plan in front of us from you for the,
Is that the current one?
yes,
73 feet. That's what I said. The tower is, what, 140 some? So that's half the tower height.
143 feet.
Would you like to see the plan that I have?
Yeah, I'd like to see it.
Didn't they submit a proposal moving it?
Yes, they did. What he's referring to is that plan there. We just found it this afternoon out of
More than
archives.
20 years ago.
About the one from 20 Indian Path from back in 1997.
Turnpike.
He's talking here about
Yeah. Yeah, he's talking about in a revised one, shifting it from that public hearing, we talked about tucking it into the corner. That's what they're mentioning.
saying he hasn't seen that.
And I apologize, Mr. Hassinger, I was
Has it
looking at
in
my
front.
old numbers before we moved the
Right.
tower
But
to,
it's quite significant, though.
yeah.
150 there.
And they also,
At that time, I think it was at least 10 feet shorter than it is now. Yeah, it's been extended at least once. So it was like, I don't know, it may have been 80 feet. I don't remember. And I don't know whether it tells us on this drawing.
it gave the 150-foot area, so I thought that was the height of the tower fall zone. I assume that's what that 150-foot circle was for, and then the 300-foot
I have
circle.
no idea what the 150, I think maybe they were showing what that distance is. It was substantially, it shows that whatever the tower was, 80 or 90 feet versus 150.
Which would have been
As
double,
information,
yeah.
it's a dotted line as well, it's a line that shows, as a matter of information. In any case, this was a different need. This was a basis of a different need. It was a very different time and a totally different board.
Well, and also that was the
folks,
build-out time.
remember
It was
this.
when that tower was needed because it was covering the area.
that's what I
This
thought.
isn't, they haven't proven the need. There's still a tower there.
Unfortunately, that's all we have whenever we do a situation like this, where one tower is gonna go away, another one's gonna come. It's a race, and I can't show it until the other one goes down, but when the other one goes down, there won't be a tower there for a little while. But I can't show that. It's a race between competitors in the industry, and
Like Black
we would ask that you give us a chance to
So
try to work
add-
it out.
Where you say it that way, just to ask, have you ever been attorney in record for another case like this where it relates to the FCC decision?
Relates to what?
To the FCC decision on a financial hardship, where you're
No.
moving a tower for this reason?
No, it's too new. I haven't had
Has
it.
there ever been a case
I've done
on
cases
this point?
before with reloads where
Which?
the race is won by one or the other, and the
Right.
boards just let both go forward.
No, but my point, and I asked the last time around, has there been any
There's,
case?
well,
Are we breaking new ground here?
I don't know of any case that precisely defines what is so expensive for a carrier that they can necessarily rule the site out. But there is case law in our jurisdiction that says carriers are not entitled to the cheapest or most economically beneficial site available to them. So if the cost, at some theoretical level, cost becomes an important factor, but again, neither this applicant nor any other carrier is entitled to the cheapest or close to cheapest site. The board is well within its rights to push applicants to better sites under your zoning bylaw, even if that has the consequence of making it more expensive for the carrier.
We pointed out that the adjacent parcel, which this 74 feet reaches to, is big enough and is positioned adequately to provide the service. They need to explore all of their options, and they didn't.
Yeah. Go ahead.
If I may, just add to this economic hardship thing. It's, as I'm understanding, it's the carriers who are protected from,
What I asked you. Yeah.
or potentially protected from, whatever, extreme or unreasonable costs or something. In addition to lacking any financial information at all, what has been talked about is the impact on the tower company, Crown. And we don't know how that percolates down to the carriers as tenants of a tower in terms of rent. And ultimately, I would imagine that the appropriate thing to look at is what is unreasonable to the carriers. They are tenants of Crown Castle, they are tenants of American Tower, they are tenants of other tower companies. The wireless companies own their own towers in places. So there is a range of monthly costs that the carriers pay for each individual cell tower site. And the tower companies manipulate their capital and their operating expenses in order to make it work. So from my perspective, it's a very complicated question to answer as to whether any cost that is unreasonable or unbearable by Crown is necessarily going to result in an unreasonable or unbearable cost by any of the wireless carriers.
Yeah, I wanted to follow up, but
And just one thought that kind of related to what you said, Bob, is that I noticed on the select board, a meeting agenda for tomorrow, they'll be discussing the draft town warrants, and one of them was for that adjacent town-owned parcel in relation to the select board being able to enter a contract or sell it for a cell tower purpose. Now, my understanding is even if we deny this today, outright deny it and then do our draft decision and everything, that if it passes at town meeting, if the select board signs off on that being a warrant, and it passes at town meeting, then they still have to, Crown Castle would still have to come back for another special permit along that same line.
all new.
Brand new process. So if that passes, which is a much more appropriate parcel, then we'd be starting this process over with brand new public hearing and everything as well. So a denial for this would not negate a resubmittal.
There's another area, if I'm not jumping in too badly, as if there's been a suggestion that there'll be a gap in service if the lease runs out, or the right to operate, the right to have the tower on that site runs out. I see two possibilities. One is that the tower gets transferred to somebody else, or the tower comes down and a new tower goes up. If the tower comes down and a new tower goes up, there'll be some sort of a gap in time. That's different than there's no service, isn't it? How, I mean, the cell towers go out all the time for a while.
Right. And I think the applicant has said that on September 20th of whatever the date is of 2020, the tower's coming down. That's the position of the applicant. I think the applicant would be foolish to take the tower down on the final day of their current lease, because even if that were to occur, they would need to file another application at another site at that time, and then you would still be in the process of weighing the various alternate locations that are available. And 20 Indian Path, even if they took their tower down, is a previously permitted site of a telecommunications tower. So it, I think, would necessarily have a leg up in your alternatives analysis that you'd have to conduct in response to that application. You would be able to look at other parcels as well. And I think, no, so if they manufactured a gap by taking their tower down, you would still have to look at what site is best situated to fill that gap in response to new applications that get submitted. And that could be the American Tower building a tower at 20 Indian Path. A brand new tower could go right up, or it could be another site entirely. But so I hope I answered your question.
People say you can't have a break in service. It seems to me like it should be possible to have a break in service if it is unavoidable.
I think my response would be in response to that alleged break in service, however long it would take, the current site, 20 Indian Path, would remain a viable, in my opinion, a viable alternative site that could support the denial of their new application somewhere else. Even if they take their tower down, somebody else might put one there.
If I look at this from a pragmatic perspective, that's a key question, is a temporary interruption of service an effective prohibition? And, I can't say legally, but from a practical standpoint, wireless carriers, as you suggested, deal with these kind of things all the time. Water towers, when they have to be refurbished and sandblasted and painted, and there are antennas on them, the antennas come off. And often what they do is they come in with temporary cell towers on wheels, or they put in a temporary mast with a ballasted base. I saw one on Chappaquiddick. Was up for like a year or two before they got the new tower put in. So this all can be coordinated, so there is no interruption in service between the dismantlement of an old tower and its replacement with a new tower. And I'm not recalling whether there are any abandonment rules in the bylaw, but generally, if a facility is no longer used or the tower has to come down for some reason, you have a period of time to replace it and still maintain your permit. And from having looked at the record, the permits were all issued to wireless carriers to occupy that site with a wireless facility, which includes ground equipment and antennas mounted on a tower. So it comes down to the finesse of interpreting whether a replacement tower on that site is covered by the existing special permits or not. But even if it isn't, Attorney Heap is pointing out that the site, it's already developed, it's already been used for this purpose. It has the utilities necessary, the telecommunications necessary, the access necessary. This is a place that the wireless carriers would be foolish to walk away from, because even if a new tower has to go up and they have to wait for that, it's the least troublesome, most cost-effective alternative for them to maintain their facilities.
Yeah, the carriers have structures and equipment inside of them. So they're already
Right.
Besides electric and communications coming in, they already have the infrastructure.
ground equipment, yeah.
Except for the wires up the pole and the,
Right,
and the
right.
antennas.
So even when we're talking about the town property as a potential alternative, I ask alternative to what? You have a working site, you have a prediction of a gap in service, you have a business situation where there are competitors who are playing the race, as one of the attorneys has said. And is that something that the board wants to be involved in, that race? Or do you have enough information now to render a decision?
Yeah. I have to say, particularly given my sense of the board's position on the requested waiver, that such a waiver the board might seriously consider granting if the demonstrated need was overwhelming. Now, the applicant has picked the location on the subject property that gets them as much distance as they can feasibly get on that particular piece of property from the neighboring houses, and certainly not from one of the property lines. It's very close. However, given the continued lack of any overwhelming evidence supporting the need for this particular site, I suspect that the board would be highly unlikely to grant the waiver. And thus, between that and the on the record at least, the lack of exploration of alternatives, it doesn't seem to me like there is much prospect of making any further forward progress on this particular application.
At this point, it seems to me that there are two options. One is to close the hearing and make a decision. The other is for the applicant to withdraw and come in with a new application that's better constructed. Right now, I'd consider a withdrawal without prejudice. Once we close the hearing, that's not going to fly.
I'm quite sure Victor would like to consult with his client before agreeing to a withdrawal. And we have members of the public here who are interested in this. I don't want to explore any territory in this hearing that we have already explored. And I think everything that's been submitted to us in writing and everything that's been said at hearings is a matter of record. We don't need to repeat that. But if we do have any comments from the public that add to what we've already put on the record, now would be a time. Mr. Whitney.
Thank you all
Thank
very
you.
much.
Thank you.
Thank you.
Richard Whitney, 13 Greeny Drive. I'm not going to get into the old stuff or anything else, I promise you that. But since we've been here for this meeting, from day one, we've heard nothing but this is our plan, Plan B. Victor has sat here with his client and saying that we're going to go with this. Then all of a sudden, we are not going to deal with Crown Castle. American Tower. We don't want nothing to do with them. We want to walk away from them. We want to be on our own. That was said to you guys. And it was said to you that at the last meeting that we will have all this information. They asked for this to be tonight. As you see, all my neighbors, a lot of them are here tonight. Then they're taking their time. And where is their main guy? Not here. Why? Vacation or bringing child back to school or whatever. And also, before I leave, I would ask Mr. Chairman if you can instruct Joe to talk to the town administrator of taking off the warrant article, of talking to the select board, okay, of Article 27, of selling that land or using that land for a cell tower off of 7 Institute Road. Also, I'll be making phone calls to the select board members, because I don't believe that should be going from one, because if they drop out of this or take it back without prejudice, we pass this at town meeting, that's, we're gonna do this, here comes right back in, closer to my house, closer to my door. So that's where I leave that. Thank you for listening to me, and it's short.
Without prejudice, I believe, would only apply to essentially this plan.
well-
The question is, if they withdraw with prejudice,
Yeah,
then the only way they can come back for 2 years, if I'm not mistaken, is if they have a substantially different plan. If they bring in a plan on a different piece of property, that's a different game.
I understand that, Bob, but the thing is, since day one, when we met with these people, they told us they didn't know who the people were. They didn't tell us, you've asked them for information. They keep stubborn, putting it in their back pocket, I'm sorry. But not giving us the information. And the thing is, and I've done some homework, and I believe our attorney here will back me up. If that pole goes down, somebody can go right back up with another pole within, I think it's 30 days by our charter, or 60 days, and use the same leases. So it's leased to the AT&T, Verizon, and they wouldn't even tell us that in the beginning. I mean, we had to drag it out of them. So where do we stand with them telling you tonight? I definitely will be back here on October 14th with this. So as far as I'm concerned, it's a dead horse in the water, Thank you.
Mr. Chairman, I can't withdraw the application, and I would like you to consider the request for the extension to give me time to respond to the 2 letters that came in Friday and today. It's just a couple of weeks. Otherwise, I want to put my case in if we're going to go forward tonight. I've been holding back talking about what we've done, but I really want to see if you're going to grant the continuance request first before we do that.
Okay, if you could hold on for a second, I do have a hand up from the public.
Hi, Dave Lindblad, 2 Old Snow Road. While I had the board here, I just wanted to ask you guys, can I ask you guys a question? Making these decisions, is there any repercussions for, at best, misdirecting you, and at worst, outright lying to you on an application process? Are there any repercussions for that besides you guys just saying no to the application?
We're not taking sworn testimony.
Well, I just a generic question. Instead of calling you up individually, I figured I'd want to do it here. Is there a generic?
Happens, I believe I've read that we could take sworn testimony, but we never have in my 28 years on the board.
Oh, so you mean, so it's not sworn testimony, so they can't necessarily be called a lie or a misdirect or a...
That's correct.
Well,
It can be called a lie, but it's not perjury, I think is the bottom line.
There's no repercussions for that? I can come up here and say whatever I want to get, I mean, just hypothetically, I could just say anything I want just to get the application and get it. And I think I talked to maybe Joe on this, and I know you guys could actually come back and say, hey, you lied about this, or you said this and it was a false statement, you could take that away, I guess. Is that the only repercussion that this board has?
our decisions, well, Joe probably can say, but our decisions include the fact that it's based on all of the information that we've received. And I think that there's a caveat in there if it turns out.
Correct. There's standard language in board's decisions for special permits that basically say that the decision is based on the information testimony received, and that false information may lead to the decision being null and void. So basically, the repercussions are legal.
So there's nothing before the decision, you use that as part of the decision?
Correct.
That's something in the decision that then if something turned up that fit that criteria, consequences could follow. So there is that.
Also, if during the hearing process, if the totality of the record includes a statement that is less than truthful, and the record also contains something that is contradictory, if the record can, for example, take two assertions of, somebody's asserting as fact, two things that are contradictory, those are both part of the record, but it should become clear that, if there are two, if there's a contradiction, it should be, the record should somehow be clear that there is, that one is true and one is false, say. So that's, it's largely a matter of what's on the record, and as Joe said, ultimately the decision basically includes language that says if the record the decision based on, if some element of the record that the decision is based on it turns out to be false, then that affects the validity of the decision itself.
Okay, and not
There
to,
are sort of repercussions, but no one's gonna come and put you in jail, put the applicant in jail, or anyone else for that matter. Anybody from the public can also make a statement that they believe to be true, but turns out not to be.
okay, just not to repeat anything, but anything that we have on that planning board page or all those notes, you guys have to review at some point before making your decision, if it went the full distance, basically.
Actually, we've been.
Looking at all as it goes.
Every hour I was logging
Okay,
in today,
gotcha.
looking for new input.
Yep.
Okay. And just one last thing, do you guys ever do, you were trying to do it, but you, for some reason, maybe I missed something, you guys were trying to do, call it what you will, I don't know what you call it, kind of like a, what's the word I'm looking for? Basically making a vote without making a vote. You were trying to do it, but I didn't really, you guys didn't complete it, like, everybody like taking a piece of paper and writing it down
No, we're-
anonymously. You don't do anonymous votes to find out, to test your waters, like, you were trying to do that.
We
but-
could, I think.
No, at first, if we're actually voting, we can't have a secret vote. It has to be open and on the record. But we're not to the point of having that decision to make. But if we can see that the economic and the carriers and all that notwithstanding, can set those, if we find that it's not gonna go anyway because of the waivers, we can cut to the chase here and save everybody a lot of time. So we're trying to get an idea, and hopefully, people haven't, people are still listening. The board members are still listening.
Okay, but you guys can't do like a secret thing between yourselves to figure out which way you're going? I thought that's what you were trying to do, but,
All of our votes on all matters before the board are public.
We can't even talk to each other over email or anything.
oh, really? Oh, okay.
No,
All of our business is transacted
all
in a
transparent.
public meeting, open to the public, and everything we do is a matter of record, including the votes. If the vote is not unanimous, it's a matter of record who voted in favor and who voted against.
Makes,
You can check the state's open meeting law.
Okay.
makes,
There's no testing of the thing, because I thought that's why you were asking each board member. I thought that's, whatever, I read it wrong. I thought you
We
were
do,
trying
you
to.
know, we
listen
may,
to
we
each
may informally get a sense of what each of us is thinking about a particular
okay.
issue. That doesn't have it doesn't have the weight of a formal vote.
Okay, thank
Bob
you.
and I have to be careful at home.
Gotcha. Thank you for your time, appreciate it.
You had a hand up there? I'll get back to you, Victor. I haven't forgotten about your request.
Matt Abraham, 17 Greeny Drive. Just wanted to say one thing. So viability of the proposed site aside, is that working? Viability of the proposed site aside, I think it's pretty clear that where the tower stands now is the most viable option. So the question really becomes, what constitutes financial infeasibility? And if you're talking about two multi-billion-dollar firms, I think it was discussed amongst the board a little bit of what that really means. And nobody's answered the question of why they're claiming that. Is rent now X and they want to raise the rent to 2X, or did they just not want to pay rent at all and they want to own their site outright? I feel like nobody's asking that question and trying to put pen to paper of what the actual money is. And until that gets answered, and you've been asking for that since day one. So I don't know why we keep granting extensions when the simplest question hasn't even been addressed yet.
Of course, there's another point there, and that is, even if they provided us some information that showed that there was an economic problem, would the law, would the, it's not an it's an FCC regulation, I think, isn't it? Or maybe it's interpretation of the law or something like that. Would it be invoked in this case?
Well,
And I think you said no.
They've already invoked it, but the new FCC declaratory ruling from earlier in the year does not state, as I said, it does not state the point that, having Crown Castle having to pay its landlord a private rent of X is too much and would require the board to let them go to another site. It does not say that.
It just seems like both parties are, I guess the client's not here. Both parties are here. They're obviously going back and forth by text or phone call to figure out information about whether or not they, are okay with an extension or not. The information's there. Both parties are here. Ask it. Why can't they tell you tonight what is so economically infeasible about the current location? Nobody will just blatantly ask and answer that question, and that's what this whole case hinges on.
Now, Victor, to get back to you, Victor is continuing to request a continuation so that he and his client can respond to the latest letters from Council for the Town and Council for American Tower. Given that it seems unlikely that the board would grant this permit with the requested waivers, I'd kind of like, I don't mind giving the applicant the opportunity to respond to information that's really, in some sense, just come to their attention in the last few days. But on the probability that it won't materially affect the outcome, I might suggest the shortest feasible continuance for the sole purpose of a brief continuation of the hearing to assess the additional information with, I want to say, the possibility of more extensive discussion if it turns out, contrary to our expectations, that might be warranted. We have another meeting 2 weeks from tonight and another meeting on October 7th, both of which are fairly fully scheduled. But if we want to think in terms of the applicant, for the sole purpose being the applicant to respond to the latest communications and then to decide where to go from there, keeping in mind the possibility that you might want to consult with your applicant about the question we raised about possibly withdrawing without prejudice or taking some other action, given all that we've talked about over the several hearings about the difficulties associated with this site, the potential alternative sites, the potential for 20 continuing operations at 20 Indian Path. There's seems to me like there are several alternatives that are open to consideration. We've only been discussing one location in this hearing, and I think we've come pretty close to beating that to death, with the exception of the applicant having an opportunity to review and follow up on these two American Tower and our consultant.
And I just want to state for the record again, this is the first time I'm asking for this. I've not been the cause of the prior continuances. Couple weeks, if you're gonna deny it then, you deny it then, but at least give us a chance to reply to paper that's flying around the past 48 hours.
That's kind of the direction in which I'm heading, it doesn't seem likely to me that there is, sorry to the audience at home, I just hit the mic. doesn't seem like there's much opportunity for forward progress, but if we do keep the hearing open for 2 more weeks and anticipate a brief continuation, at which time we ought to be able to make a pretty firm decision, withdraw, close, or if additional information does change, bring in some new possibilities of further continuation to more deeply deliberate, that I could be comfortable with.
But it would have to be very.
So we can't just ask the question tonight about,
We've asked it.
but, so why can't we ask American Tower?
We did.
We did.
Yeah.
Are you all of a sudden gonna raise your rent next year? Is it
Well,
doubling? Why?
That's their negotiations. That they're not
Why-
going to tell
But if
us.
that's what this whole decision hinges on, why isn't anybody, we've asked for the information and they just keep denying it. They obviously know. So somebody needs to answer the question.
Can I briefly address if
Yeah.
applicable? So we have no intention to make the site economically burdensome for Crown Castle. We just are asking Crown Castle to propose new terms, because at this point, we don't know what they want. So we want to work with them, so we can't really name anything, and American Tower can't really name anything right now with the terms, because we've asked Crown Castle to do it, because we want to work with them, and we want to make it the most feasible for them to remain on the site, because we understand that's the best option for the city. So that's why I can't exactly answer the terms of your question, because it's really Crown Castle's burden at this point to say what they think is economically not feasible when we've presented every option that we have at this point for Crown Castle to make an offer to us. So by no means are we increasing our rent exponentially like he had
No, I was just asking
said,
the question.
but, no, and I understand your concern, of course, because it seems like we're all just beating around the bush in some sense, like how you had discussed, so. I just want to make it clear that there's no intention for American Tower to raise the rents some crazy amount, so I just want to make that
The point has
known.
also been made to us by the attorney that even if you were, the negotiations between your two companies are not something we should be weighing in this as far as economic hardship, since it's only the people, the carriers,
That's
that are
correct,
the
yeah.
ones affected by that law.
Yeah.
And that for us, the issue we're looking at is whether or not we're willing to grant a waiver on a property for a wireless facility that doesn't need to be built.
Right.
So the issue is not really your negotiations. That's not really any of our concern. What our concern is this particular property and what we're looking at, the permit.
The,
I have,
there have been points raised. You've mentioned this new correspondence, but it's just reinforcing what we started with at the first hearing, when we asked this. You've had lots of time to provide that information, and you've declined to provide that information. You had your chance, as far as I'm concerned. So I'm not in favor of, I'm not in favor of on and on with hearings. This is, for 28 years, I've been not in favor of letting hearings go on and on. If the board does decide to allow a 2-week continuation, though, I'm going to insist that your input is in our hands 7 days before the hearing, so that we have a chance to pass it on, so we don't have our people seeing it the day before, or the day of the hearing.
I second that.
The only information that well, okay, I said it.
I have one question, though. Did American Towers become the new owners for that land very recently, or have you been owning the land or leasing the land for a while?
Well, it was, I believe in 2014, we gained the easement rights. So it's
Okay.
just been the last 5 years.
Okay. The reason I ask this question is the application says that due to change in ownership of the underlying ground space, the applicant and its subtenants are now faced with involvement of an additional unanticipated third party in the operation of their facility and equipment. I'm assuming that refers to American Towers, unless otherwise it is something else. If that refers to American Towers, 2014, 2019 is significantly a large time of period of time in the last 5 years, this never came up for conversation. So substantiating your point, Bob, either the application was not complete, to start with. The second part of the application says the applicant and the subtenants are facing economic hardship, or it's not economically viable for both the carriers and the applicant. So missing lots of pieces to the puzzle here. Thank you for that.
Yeah, it's not been in the last 2 years or less than that. It's been a fairly good amount of time that we have had the easement rights, so.
Okay, thanks. And I agree with Bob to your point. If we do, Chairman, if we do extend it for 2 weeks, I agree that the information should be available a week prior to that, so that we don't sit back here talking all this all over again.
Yeah, this is, we need to bring this to a close as quickly as we can, one way or another. It has to be brought to a close.
And the whole reason why it's been extended by, if you will say, the board, is because they brought in problems. There were things that weren't clear in what they were presenting that we had to have clarified by extra counsel. And that's, so in a way, we didn't generate that need for an extension, for this delay. It's because of the lack of information that was given to us that we had to go really further down the road. So 2 weeks?
Well, it's up to the applicant to make a request for whatever continuation. In light of the conversation here, what you would like to do.
Yeah, we would request that you continue it for 2 weeks, and I heard get you additional information by a week before, so to me, that would be continuance to 9/23 with info to the board by 9/16.
That sounds correct.
That'd be my request if the board's willing to entertain that.
So I will make the motion, I guess.
No,
Go ahead,
he
Bob.
does it.
He needs to
I'll
write up,
finish.
we have a form for you. Well, you should know that by now.
Yes.
We don't have to worry about that right now.
Yes, come up to the mic, of course.
Richard Whitney, 13 Greeny Drive. I don't mean to be disrespectful. Victor has been talking to this young lady here with the white shirt, and she's texting. Now, she's texting to, she's supposed to be the project manager, I believe? If that's, okay. Then why can't you follow along with him right now, because you're the project manager, and settle all this tonight, instead of talking to your supervisor, which is the gentleman that was here with you last time, that him and I got into a little scuffle together. So if you're the project manager, you're managing the project, and Victor's working for you then, basically.
I don't have all the information that's necessary that's being requested here.
I have no idea what
Okay.
you're saying.
Yeah, I'm not sure that that's question is
No,
particularly
I'm just
relevant.
saying, I mean, I'm asking this question. If they're not giving us all the information, you the information, asking for an extension, but she's the project manager, she should have, as the manager, should have everything with her to do this, but she's texting somebody else, her boss, the owner, and saying, we're doing this, can we go off 60 days, 30 days, 90 days, whatever? And it seems like they're just doing business right behind our backs and, making everything work again. I'm just saying, why can't she get up here as the manager, speak with Victor?
I don't know that she's authorized to do that.
Well, then why is she here tonight?
Victor is representing the client, and I think it's up to Victor to decide who he will use to speak on behalf of the
Okay.
client. It's not my business how the client does their
I
own
know it's
business.
not our business to ask them how much they're making off of each one, but at least if she's the project manager, she should be on tap of what's going on of doing this.
All right, I believe we have a written request from the client for a continuation in hand.
Yes, so I will make the motion to approve the client's written request for continuance until September 23rd at 7:30 PM. Grant.
Grant. With the 16th clause.
That's not part of the,
Yeah,
that's,
I don't think we can mandate that, but
that's,
it will come
that's
to
an
our decision.
understanding
if we-
that the applicant has taken notes of and has acknowledged the board's request.
Okay.
But that doesn't
Second.
have to be a part of the motion. Moved and seconded. Discussion? Hearing none, all in favor? Aye.
Aye.
Opposed?
No.
Um,
So the vote is,
Did you vote in affirm?
Oh, yes. Sorry.
Yes.
You opposed? I didn't hear the vote. Yes, I'm voting yes. So we do
voting
it.
yes. You're voting yes. Dave, you're voting yes. And you're voting yes. And I'm voting no. The law requires a roll call vote.
Yes.
Okay.
But, by the way, you would know better than anybody else, if that goes to town meeting, if that warrant article goes to town meeting, is that a majority or a two-thirds?
I think that's a two-thirds.
Yeah, I'm pretty sure
Oh,
two-thirds.
good luck.
It is.
He's the assistant moderator of town.
Thank you.
Yes, so, for the record, the vote is carried by the motion is carried by a vote of 4 in favor and 1 against. The roll call is noted.
Thank you.
2 weeks from now,
Everybody.
Mr. Whitney.
And thank you all for your participation and your patience.
I guess we should have first asked, are you available?
And as soon as the parties to this hearing have departed the room, we can get on with the other one.
Are we having fun yet?
Stenographer.
Are we having fun yet?
Thank you.
By the way, Joe,
Yeah.
I got a chance to really look at the transcripts, and I was, compared to previous ones I've had to look at on other things, that was pretty good. I had to look at the transcripts from the deposition for the other cell tower case, and I suppose it had something to do with English, but nothing that I could recognize.
Yeah.
Did you hear, I looked at your transcripts from,
Oh, you did?
yeah, and compared to others that I've had to look at.
Oh, well, I'm glad to hear
Very
that.
good. I don't know,
Thought you were gonna
I
tell
have
me
no
that-
idea how you capture all that.
You didn't tell me I had something in there that was,
No, good work.
Remember, you're talking to someone that's been on the board for 25 years worth
Yeah.
of cell towers.
he's probably looked at quite.
28,
20, sorry.
I'm just gonna unplug this before you start again, so.
spring of 91.
I think we're still on camera, technically.
I'm sorry?
I think we're still on camera, technically.
Oh, great.
I just graduated from high school.
Okay, I do believe we are now ready to proceed with our second public hearing of the evening, which is a continuation of the public hearing for a major residential special
Yeah.
permit and preliminary plan approval at 11 Wheeler Road.
That's probably gonna be best. The challenge is they won't be able to see it. The plans that I have, I can put on here, but you're gonna be blocking them a little bit.
It looks okay, Joe.
All right, so tell us what has happened with this since the last time we met.
Yeah, so since the last meeting, for the record, Travis Brown of the Andrews Survey and Engineering here on behalf of Stan and Lisa McGriff. So since the last meeting, the board asked us if we would consider an affordable unit as part of this project. We looked into the feasibility of that. It's not feasible at this scale, size project. So what we've come up with is we're looking to pursue a conventional plan. We changed that. We understand the Conservation Commission has recommended the flex plan. We went back to the drawing board, provided a updated flex plan. that shows the open space areas that would be in green as part of this, which is, meets the 40% requirement. It's approximately 2.75 acres. Speaking with Rob Aberg from the Land Trust, that would be something that perhaps could be deeded to the Land Trust, becoming part of that land as part of this project. So instead of the 15-foot strip that we previously had adjacent to the trail, now we're upwards of about 55 feet. Provide some buffer to that trail. In addition, we provided some area back here that's within 200 feet of the riverfront, which protects basically all that riverfront. This stretch here provides about 65 feet a strip that would abut the Land Trust as well. So all of that open space that we designate as part of that 40% would be contiguous with what is now Grafton Land Trust land. We also incorporated the land swap, which is here and here, to be able to bring that infiltration basin away from the trail, away from that Grafton Land Trust land that was previously shown on the conventional plan. We incorporated it into this design that you see now. We also understand that there's been some issues as far as water with that trail that has some muddy sections. We kind of threw out the idea of a boardwalk at the last meeting, which is high maintenance, not a great solution. So we've talked to Rob, and potentially there could be something in place to provide a gravel bed or fill that would provide trail maintenance and help with that situation. So that's the changes since the last meeting. We discussed traffic to some degree at the last meeting. Again, we provided a memo to the board. We have an adequate intersection as far as sight distance. No limitations on site down to Route 122, and then adequate sight distance north, west up Wheeler Road. We understand there's issues with the existing intersection. This project won't solve that problem. But at this size, it's not gonna impact that existing problem at that intersection. So that's what we have come up with since the last meeting.
I guess I should mention that an email came to me, and it's been with a comment from a citizen, from Ken Crater, and I've passed it on, and it has just in the last, today, been posted on the project page on the website. So he offered some input on the matter. I'm disappointed that we can't get the affordable. That had a chance of being a significant benefit to the town, in my view. It's not going to happen. I think that we have to be looking, I hope that we're moving towards a bylaw that says that all subdivisions have to have enough affordable content so that the town doesn't fall any further behind in its quota, its requirement for 10%. We'll see what town meeting, we'll see what the board and perhaps town meeting does about that in the future. This would have upheld that principle if we could have gotten a unit.
Other comments, questions from the board?
The question is, what are the waivers, or are we providing any waivers as part of this?
Distances to intersections.
Yeah, the key sticking point here is that the proposed intersection of the subdivision road is less than 600 feet away from the Meadow Lane and the Worcester Street intersections.
Yes, and I don't know that we've ever granted that large of waivers. And as I mentioned earlier, granting waivers comes back in the future. And we've had that, in fact, the distance to intersection come back to us in the past and work against a decision, work against decisions we've made, even long into the future. So I look very carefully at waivers. These are big waivers. I need a big justification. I don't have it.
And Bob, if you can also help me, what is the risk with this waiver? For 600, what is the risk associated with the 600 feet waiver?
The rule, the town and the planning board has decided what sort of road network it wants. And it doesn't want streets every 200 feet, intersections every 200 feet. We had one subdivision where there was a road across the way, and they were gonna come in over here, and they had to make their road bend so that they had a straight across. In fact, uphold that principle.
Okay. And if this was, if it was not the 6-unit piece, and if it was still a 2-unit piece, would that still be the intersection point, or would that be a
No,
different?
then that's just,
They have but that by
that-
right.
that's approval not required. Those are just frontage. He has enough frontage for the existing house and 2 more houses on the road.
One more house.
2. I checked on the town, and there's just over 3 times 140 along that frontage.
Even with the required setbacks from the existing building?
I don't know about the setbacks. That's subject to a variance in any case.
So if it was, to your point, 3 houses, is that what you're saying?
The existing house plus 2 new houses.
Okay, would that
Yeah, I
still
think it
be-
lacks frontage by getting that third lot. I mean, that's, you know, a moot point. I mean, this is the project that, you know, we're here to discuss and try to, you know, come to some resolution to provide public interest where this property is adjacent to the land trust, 2.75 acres of land, valuable land to the land trust, whereas this project could be developed, you know, under other mechanisms that could maybe provide that affordable housing to the town of Grafton.
It would help the town's position, and it would produce less potential revenue, profits, because 40B has limits on who can earn how much. So it's, you know, people do it, and it would get us some houses.
Yeah. You know,
Some affordable houses.
you know, the McGriffs have spoken here. They live in town. They've lived here for a number of years. They're trying to develop their property while also working with the town, you know. In this scenario, that we can't change this piece of property in proximity to intersections. We're trying to find the best solution that provides adequate site distance, adequate traffic impacts, while also providing public benefit to the town. So the statement that this project, you know, might set the precedent for others, I think you need to look at it by a case-by-case basis.
Well, I thought that too, and our town council and the people who represented us in court didn't want to do that, didn't want to pursue that, even though it was doable. And the Board of Selectmen decided not to pursue the case for us. It's clearly the way it comes out. If the threat of a 40B invokes waivers automatically, then we don't have any rules. Because you throw that threat out, and we have to give in on all the rules and waive them. I'm not going to do that.
At least for me, where this is in town, the distances from the road and the size of the development, it really does not feel as bad of a waiver as, I understand your point about precedent, but I think the size of it is also part of the precedent we would be setting here. Rather than just the fact that we granted a waiver. It's the size of the development and the layout of the area. That's my interpretation.
And whether we like it or not, or agree with it or not, the subdivision rules regarding the two that always come up, or frequently come up, I won't say always, that's an exaggeration. The two that frequently come up are this one, the distance between intersections, and the dead ends, the length of a dead-end street. These two rules have the effect, like I said, whether we like it or not, they do have the effect of seriously constraining the ability to develop certain parcels of land. And until those rules are changed, those constraints exist. And you can't have rules, and yes, rules can be waived, and it would be worse if the rules could never be waived. But you can't have rules with some ability to waive them without having to deny a requested waiver at some point. Because as Bob says, if you're willing to always waive the rules, then the rules don't really have, you might as well not have the rules. Now maybe, this is sort of off the topic of this particular development, but maybe the planning board wants to revisit those subdivision rules and reconsider. I mean, these rules have been in existence for a long time. They're created by the planning board, they can be changed by the planning board, and if the board someday should choose to change these rules, they can. But these are the rules that we have to go by. And I don't always like the results of the rules. I don't like, rendering land nearly undevelopable. But the way to fix that, if you think it's broken, the way to fix it is to get the rules changed.
The rules actually encourage assemblage of property to the point where a development that does comply can be built. In other words, we always end up looking at this as, I have this one parcel and I want to develop it. Out there in the world, people assemble parcels until they have a viable project. And that's one of the effects of our rules. The planning board, one of the planning board's basic jobs is to direct the development of the town, what the road network should look like. I don't believe we should have all the dead ends. I believe we should have an interconnected network, road network, for example. And our rules are aimed at least making some effort at getting that. That also goes back to assembling land into appropriate forms for development.
So
If I may address the board?
you may.
Thank you, Chairman. I would like the board to consider the uniqueness of our situation. We abut that trail, and we abut Montgomery Woods. Comes from Montgomery, who used to own 11 Wheeler Road, and they gave Montgomery Woods from 11 Wheeler Road to become Montgomery Woods, as the trail originally come from 11 Wheeler Road. And now, uniquely, we would like to do this project, and as the board can see, we feel this is hugely beneficial to the community. It gives the trail, I know some of you probably have never walked the trail, but it's very unique, and it's loved by many Grafton residents. And to have a buffer zone there where now it's not just this little trail with us being there and we could do anything, I mean, not that we ever would, but whatever, we would give all 50 feet or 55 feet all along the trail now is wide open. And not only that, of course, along the back where there's a creek, and it wasn't mentioned today, I guess, but there's certain rare flowers that grow back there, and though that would give them in perpetuity forever, they would be able to grow, and the flora and the fauna, it's all unique property in a unique situation along a unique trail. And we would like the board to consider that uniqueness. Now, I do agree that rules are necessary. However, there is certain times when a waiver might be appropriate. And I don't know if every town has this rule where you can't have a road right this close to an intersection, but, you know, Grafton does. And other cities, towns, probably not, but we do. But we would like, my wife and I, and all of our relatives, would like the board to consider the uniqueness of our property and our situation. As you can see, we've revised the plan to give up 2.75 acres to Grafton Land Trust, and we would develop the 6 houses with what's left. Thank you for your time.
What is the distance to the roads if it is less than 600 feet? What is the actual distance right now? I'm not very loud and audible, I guess.
It is about 290 feet from our intersection to Route 122.
How about the other intersection?
To Meadow Lane?
So that is actually off the page. That was just under 400 feet, right around 400 feet.
Personally, I don't see anything really objectionable about this plan. I don't see that there's any opportunity for this parcel to connect the road in any other way, unless they were to purchase 2 adjacent parcels going up Wheeler Road. Then they could have an intersection coinciding with Meadow Lane. But it's really that's the only way for this to be done within the rules. But I don't see anything really objectionable about this, other than the fact that it doesn't meet that particular criterion, that's that rule.
Intersection.
Yeah, it's just that that's critical to me.
And just to ask it for my understanding, just to be clear, the stormwater mitigation is closest to Wheeler Lane on that, in the section of green there, that's part of the Grafton Land Trust that you're going to be donating, is that still something that you're erecting in that spot, so to
Yes.
speak? Okay.
So that would be part of the land swap. On this plan, we'd be providing this wedge here to the
Yep.
land trust.
Thank you.
And of course, there is, on the record, there is an objection to the very concept of building more than 2 houses on this property.
Yes.
Yeah, the comment I mentioned that just went up tonight.
And that comment had been made in the prior hearing as well. And as Bob generally never fails to note, if he is the only one objecting to a waiver and 4 of us are willing to vote for it, the waiver can be granted.
And did you guys also in the plan look at, can one of these be affordable housing, or
He said no.
is that no?
We looked at it. Yeah, it's just not feasible at this scale. If you're building 40 units, you can afford to maybe do some units affordable, but where this is only 6, financially, it just doesn't make sense.
We hear that at every scale. No. I can name some other cases,
Yes, that argument is not unique to this case, shall we say.
or this size.
But in the last meeting, I thought you were okay with that concept of one of these, or you would look at this option of some part of the property being affordable housing.
I do recall them saying that they were willing to consider that, which
Consider
they
that.
have.
They did, they said they did.
You know, and as always, it comes down to, can we, will we at least break even on this project if we include an affordable unit? Because it has a very definite cost associated with it.
From my personal opinion was getting that land for the trail and having that accessible for the Cub Scouts and the folks that use the trail. That was a big thing that you guys have done. So that is one. And then the second one was, I know when the boardwalk was proposed, the maintenance concept of it. So those are things which are great. Going back to, in my last few months of being here, Bob's point is, what is the bigger benefit? What is the community getting as benefit? Is that benefit significant enough that a waiver is feasible or makes sense or not? I get your perspective of the cost-benefit analysis and is this even financially viable or not? The flip side of sitting on this side, not wearing my business hat, thinking about it is the benefit good enough, big enough that we can grant a waiver? That's what I'm trying to debate in my head.
I just want to say something that,
Gotta be
Can't-
at a
You
microphone.
have to be at a microphone.
sorry, my name is Lisa.
Using one of the mics.
Since we've been living there, there has been people who do walk the trail that are on our property. They come up and see the horses when we had horses and things like that, but they do use that part. So when we thought that buffer zone for the land trust would be great, because it's the property that they walk on, that they do use.
It is. I do agree. It is great.
Yes, you were on our property.
Yes.
So.
We were trespassing.
So
but
that's
part of Cub
why,
Scouts.
yeah, that's okay. The green part that, I don't know, it's 2 point whatever acres it is, we just thought it would be great for the community. And that's what we came up with. Thanks.
I think we are getting to a point with, certainly, I'm not going to close off discussion but I will suggest that we're getting to a point where the applicant has probably explored as many alternatives as they can in terms of finding ways to design and configure this project to maximize what public benefit there is in the project. And, unless there are some new ideas or new information that we have yet to explore, we could be looking at, depending on how the rest of this conversation goes tonight, we could conceivably be looking at closing the hearing and the board drafting a decision. But at this point, the opportunity for additional information remains open, so I think I saw someone interested in speaking.
My name's Justin Compton. I live at 13 Wheeler Road. So I guess I don't, I have something I've written down, so I just don't believe there's any rationale or justification, and I just don't see any public interest in waiving these portions of the subdivision regulations. It just, the regulations are in place for a reason. And when we purchased our house, just like the applicants, when they purchased their house, these regulations were in place. And we understood at that time that there could not be development of this scale adjacent to us. They have the ability to build lots per the frontage, right? And we just assumed or thought maybe that would occur at some point. And with respect to the proximity, I think is even more pertinent to maintaining this level of regulation with respect to where it is adjacent to the Grafton Land Trust. This is a valuable area, as everyone here has noted. This is also a sensitive sort of watershed area. And so I think it's imperative that this unique habitat in this area is protected. And part of that is, you know, maintaining the regulations as they are. I think I just don't see any rationale or justification for granting this. There really is no benefit per the town. And I think there would be only one party that would be really benefiting from this granting of this waiver. I think that's kind of all I want to say. I just don't see any justification or rationale in this area. So.
Okay, thank you. Any other comments?
Yeah, we need to talk about one more thing.
Yes.
This comes from a neighbor who moved our boundary lines the day he moved in.
And has been using our property since the day he moved in.
So note, his speech is with some history.
How did he move your boundary line?
Okay, shortly after he bought the property, he had the back of the property cleared, and my wife and I had recently had it surveyed. A rock wall runs along the back. An orange pin was put by the surveyor in the rock wall. When he bought his property, and once he got in, he came and had a large machine, an excavator, went back and moved that boundary, buried the boundary line. It was recently surveyed, clearly marked, and he's been using our property ever since. Now, he came and I mentioned it to him. I said, your excavator did away with the survey. And he said, oh, I didn't see that, or whatever. But anyway, here's a neighbor that's blatantly been using property that hasn't been his for many years.
And we've allowed him because we're good neighbors. And we've been good neighbors.
So
for the
let
whole
me
10
just
years.
say, he has alternative motives.
And we have been great neighbors with him for all these years until we want our project to go through. We even offered, he asked us if we would sell him that part of the land. We were going to. But all of a sudden, it doesn't benefit our community anymore.
Can you show me on the plan where this moving of the...
He buried this line and has been using this property ever since. And it's been okay with us because we don't use it. But we take umbrage to the fact that he doesn't want to look at houses through the trees. Well, before he moved in, they built his house pretty close to our front kitchen, and now we look out and see his house all day, all night. So now he doesn't want the same thing to happen to him. Well, we welcomed him, and now he doesn't welcome us.
I've been wondering about that 30-foot strip.
Yeah, well, now we want this for access to back here.
For us. So that's where that is right now.
Yeah, Rob, I think you had your hand up.
Me here.
Whichever you feel more comfortable.
Okay. Hi, Rob Aber, Grafton Land Trust, 43 South Street. I reviewed the plan the guys came up with. It's, really took into account everything we asked to look at. The one thing Travis and I were talking about was the Land Trust is interested in moving the infiltration basin farther back from the trail if possible. So if there's further land swaps, we're open to discuss that, if that would be okay with whoever decides where infiltration basins go. So we have flexibility. The Land Trust position is we're flexible on anything that would move this basin away from the trail to reduce the hydraulic pressure that would well up at the trail area. And then we also talked about, instead of a boardwalk, which our pressure treated in wet areas lasts about 10 years, so every 10 years you're buying a new giant deck, that maybe a permanent, talk with Stan and Travis, that if we're gonna do something to the trail to control the mud, that maybe some kind of crushed stone or something like that might be a better solution. So we're flexible on all that, so we don't have to write anything in stone at this point on what the exact solution would be. So, you know, we're not trying to say everything's like one way and only one way. So we are flexible on anything that would move the basin, and this is responsive to the concerns about providing a buffer zone.
Overall, though, do you have a position relative to build it or not build it?
Well, I mean, land trust is supposed to be for open space, but it's not our property, it's his property, and he's here making a bid to you guys. So, you know, on this particular project, you know, it's seems like it's more up to the roadway is where it's at right now. It does provide a benefit to the land trust, and the land trust is a benefit to the community. So following that chain of logic, there is a benefit there. It's a 2.75 acre.
What I'm trying to do is measure the amount of.
Yeah, that's more difficult. You guys have more experience in that. I'm the newbie here, so I'm gonna look like a newbie if I make too many pronouncements.
The land trust, there is a trail.
Yeah,
Am
it's
I
actually,
correct?
yeah, they've drawn it
Yes.
right here.
Right,
Here's the parking areas right here, and the
There's the
trail
trail.
goes along here.
So there isn't, you're not gaining a trail. You're not gaining access to the back, to the woods.
That's true.
There isn't a gain from that point of view.
From the, yeah, started, today it's open space, or it was a cart path in a barn. But it's the way it is today is the way it is today, and there's a trail. And the way it is tomorrow is, it could be a whole bunch of houses, 2 houses, 6 houses. So relative to another 6-house design, this design is better than the previous 6-house design from the land trust point of view.
Right, but it doesn't actually really truly impact the trail that the land trust already has that goes back there.
Well, so some of the concerns at the last hearing, or it's a hearing, right? I want
Yes,
to use it right
it's a
now.
hearing.
Okay, at the last meeting we had, the concern was that the small strip would still allow for a yard runoff and some other things. And so my understanding from this plan was that the yard runoff was reduced or eliminated by the way, there's a lot of topo right here, it's very steep. And so if you had something back here, it would flow back. My understanding of the new grading is it would put more into the infiltration basin. And that's, you know, and that the infiltration basins have moved away from the trail relative to the previous proposal. It was iteration 1, it was close. Iteration 2, we came up with this swap, and now iteration 3, it still shows the swap. And we're flexible, Travis and I were talking about, and Stan, we're looking at ways to move it even farther back to maybe perhaps have no impact to the trail. And so between the buffer, and remember this is a big hill, so when you're walking on the trail, you're not gonna see a house up there anymore, because the hill should block the view of most of the house. Am I answering your questions?
Well, the point is, though, in looking at benefit, we have to look at the fact that there are 6 houses, and hardscape, and grass, and all of those things come into play, and we have a waiver that we have to meet, and houses don't actually benefit the town. They really don't. New businesses benefit the town. Houses don't. And they bring with them more pressure on the schools, you know, all those things. So when we look at this, we have to look at it that just because it can be done, should it be done, it should be grant a waiver. We have to weigh these things out.
Yeah, so that's where, I can give you the facts of the
Yeah.
assessment, and weighing it, I probably missed something. I mean, how much does this, adding 1 student cost to the school system, and what is it, 2.3 children per household? I'm sure you guys have those equations burned into your brains at this point, right?
No one agrees about that argument, but if you
okay.
look in the, take a macro view, more houses don't help with the schools. You can, particularly when you have like 5% non-residential tax base. I don't want to get into that.
Yeah. Well, so I can answer questions about land trust things.
Okay, thank you.
Oh, does this push the existing trail back at all because of that land swap?
We hadn't proposed that. There are places we could now consider that, especially parts of this shark fin, or, you know, what do you call this? To me, it looks like a little shark fin. That, I think this is the muddy section of trail right here, and moving it closer to the infiltration basin is uphill, which is good, but closer to the basin is hydraulic pressure, so we haven't proposed a trail move yet.
But I've forgotten now about this land swap that they were talking about. Which piece of it, maybe point over here.
Okay.
Which piece?
If I'm wrong. Sure. But what we were looking at before was the infiltration basin would be up here in this, I call it a shark fin, I don't know what else to call it. I think Travis has a more technical.
Well,
Okay, it was up here, right close to the trail.
Right.
And so that concern resulted in iteration 2, which was the conventional plan, and this is the iteration 3. By the land trust, we have this square here and a little strip along here. This square, Travis calculated an even area land swap where we give up, the land trust gives up a chunk of this square, which isn't really used right now. These are the concrete steps for reference. The land trust gives this up and gains this where the trail is. I mean, you can almost reach out and touch the survey stakes. And so this moves it back, what was it, like 75 feet, 70 feet? Do you remember?
60, 65
Okay.
feet.
60, 65 feet. Where it was going to be the embankment, you can almost run your finger along it before. So that was a big change that really reduced the pressure. And so the land trust, no matter who owns the green spot, and we're hoping we do, that the land trust would get this little pie wedge out of the shark fin in exchange. It's an equal area exchange.
Remind me where the current land trust board,
There's 2 parcels. One is the Montgomery Wood that goes off into infinity. And then this little square here
Right.
is a separate parcel, it's deeded separately.
but I'm interested in, when you leave the square and you start back towards,
Okay, right now it's here.
all right, okay.
This is the property line today, and then this square as well. And then down, the other boundary is the river boundary, or whatever you call it.
If I may add one more thing. So my experience of the trail is what is shown as the brown line, that is the defined one. But when we go out there with the kids, when we have our den meeting and pack meeting, if it has rained and if there is water coming up, we actually, that's what I said, we trespass, literally. We get into the property, and it's a clearing.
Yeah, right.
So it's a clearing, yeah, we come over, we walk over, come
Oh,
here,
you
there is
go
an
way
old
over.
dilapidated house there, we
Uh-huh.
walk past that, and we have our meetings there, and we go Jolly Bay, so that's the way we do that. So it's a clearance. We hope and that's only one perspective, Bob, I'm not pitching in the whole thing. From that perspective, whoever uses the trail has a larger area for their walkabouts. That's one part of the story.
And Rob, just a quick question.
Oh, yeah.
If this development wasn't happening at all, would that land swap be beneficial to the land trust even by itself?
No, because it's, the main thing is, the goal is to move the infiltration basin back.
Okay.
So the benefit is it gives the development the ability to move the infiltration basin to a better hydraulic location.
Oh, yes, I'm sorry. I move that we vote to extend the meeting beyond 10 o'clock. We have a
Second.
I'm just answering questions at this point.
We have to do this. This is a, this is a technicality.
This is a necessary procedural interruption.
Okay.
Moved and seconded that we extend, that the board vote to extend the meeting past 10 o'clock. Discussion, no.
It's
I'm
only
gonna- I'm gonna-
necessary because the board adopted a policy a long time ago that it didn't need to.
All in favor?
Aye.
Opposed?
That was when my
Declare
meetings were running long.
For the record, who seconded?
Who seconded?
I seconded.
He did.
Okay.
The other way around.
Oh, the other Hessinger.
All right. Any other questions for Mr. Aberg here? Any other comments, Rob?
Nope.
Okay. Is there anything else from the public? I think,
One last alliteration, if I may.
just to wind up, Stan McGriff once again. The trail now is muddy in a spot, real muddy in one spot. And as mentioned, benefit of the community, there's already a trail there. Yeah, you can, it's fine, you can slop through the mud. Somebody might lose a boot here and there, but yeah. Well, we would, and have Rob and Travis mentioned, along that muddy area, we would, Rob mentioned stone would be good there. And we could do that along the 50-foot area, and that would help the mud immensely. For the walkers, it's a big deal. For the hikers, it's a big deal. Also, if the trail was ever needed to be moved, now you'd have that property. Right now, it's right along our edge. And sure, the trail isn't on our property, but we're going to give you 55 feet of it. So to us, that's benefit of the community. And that's about it. Thank you, board, for your time and your patience.
It's kind of a procedural matter here. Just a reminder, what we're dealing with, for those newer on the board particularly, is a major residential special permit and preliminary subdivision approval. Now, we've heard some discussion about maybe moving the basin, sort of tentative, some ideas about improving the trail, but nothing definite. These sort of things would come back in if the board were to approve this. The next step in the process is a definitive subdivision plan where details get worked out and changes are typically made between the preliminary and the definitive. So, for example, it could be part of the definitive process to determine the exact location of the basin and to determine other things if the project were to get that far.
Except that this is a factor in deciding to grant the special permit. It should be included as a condition in the special permit. When you come, if you don't have it as a condition or a commitment, written commitment as to where it's going, you don't have much to work with when you get to the, we say,
Yes.
no, I don't like your definitive plan because you didn't do what I thought you might do.
Yeah, and I think my point here was that we don't necessarily have to have on a plan the exact location. But you're right, given that it was raised as a topic in this discussion, the need to, or the need to consider at least, or finding a location with a basement that's agreeable to all parties involved, something like that. That sort of thing, yes, it should be included in the decision, even though the exact details remain to be worked out.
Because that, to a degree that's satisfactory to the people who vote for this, could be the deciding factor in how they come down on the decision on the special permit.
Could be. So having said that, is there anything else the board wishes to ask, or Joe?
I'm just looking through. I'd like to remind the board that while the board had voiced its concern for its preference, we have not received anything in writing from the applicant.
That's required within 7 days.
What we had provided at the last meeting prior to the continuance, what our preference was.
Did we vote the preference?
Actually, I'd have to.
I don't recall that we did.
Yes, because they only have 7 days in the bylaw.
Yes. I don't recall whether we expressed a preference.
I think I don't recall voting either. I think we might have talked about it, but we might have.
So at the last meeting, you were waiting for the Conservation Commission to give their recommendation, which they.
That's what I thought.
That's what I thought, yeah. And that has to happen, and we have to have their written decision on which to go with before we close the hearing.
We've received that, and that's Exhibit 19 in the record.
Yeah, so
what does it say?
At last night's meeting, the Conservation Commission reviewed both designs.
Yeah,
and vetted.
okay,
Right.
with conservation.
But that's the conservation. Right. The point is that we have to vote, then they have 7 days, and we have to get what they have 7 days to give us before we close the hearing, because it's got to be on the record.
That's basically, I just wanted to make sure that you didn't
Right.
close the hearing without receiving that.
Well,
make sure
we
we
have
have
to
that-
do a vote and then
Yes.
receive it.
So-
Sometimes that happens all at the same time.
Well,
So would someone on the board care to
okay,
move?
I move that we ask the applicant to
We recommend the,
recommend the flex and ask them to make that formal to us.
We don't have to ask.
we don't have
Oh,
to
we
ask
don't
them,
have
that's
to.
part
have
of
to
it.
vote our
That we
preference.
recommend the flex
We
plan.
recommend flex. So you're moving?
Yes.
So moved.
No. she
Linda
moved.
I second.
Prabhu will second.
Whatever.
Moved and seconded that the board recommend the flex plan. Discussion of the motion? Hearing none, all in
Oh.
favor?
While we're on discussion, because I'm trying to think about writing decisions. And right now, there's a couple things that are open-ended. We've only had verbal testimony about a commitment for some sort of gravel or anything like that. We've also only had verbal as far as working with the land trust, as far as seeing what would work. It would be beneficial if within that 7 days, there can be more of a written, say, commitment to work on both of those things. So I actually have a document to state, rather than referring to findings as, in the findings, referring to meeting minutes as far as testimony that's stated.
That's separate from us voting on our preference, though. That's not a part of our expression of
No,
preference.
and unless the lack of such a commitment would change our preference.
I don't
Although
think
I
it would
sus-
change the preference.
No.
I just want to make sure that as
Yeah, well, we're getting
keeping
there.
track.
We're getting there.
I'm worried someone's got, because it's past 10 o'clock, but, or in 30 seconds will be past 10 o'clock, that all of a sudden that motion to adjourn happens and it's not debatable and I don't have a chance to raise
We'll-
it.
we'll-
back.
I will
work this
assert the
through.
chair's privilege to not recognize a motion that the chair thinks is inappropriate or ill-timed.
We're not going to have a motion to adjourn while a hearing is open
No.
and not continue.
I would declare that to be completely out of order.
Yes. Okay.
All right, so the motion on the floor is that the board recommends the flex plan. Is there any further discussion of said motion? Hearing none, all in favor? Aye. Opposed? Declare that motion carried unanimously. Now, to reiterate a couple of points here, it is apparent that the hearing needs to be kept open to receive on the record, at a minimum, the applicant's choice of which of the two plans they are going to pursue. You know that the Conservation and Planning now have both recommended the flex plan. It appears that you are proposing the flex plan, that is your current preference, but we need that in writing. Just inform the board. Dear board, we are going to pursue the flex plan.
Can we do that right now, or do we?
No, you don't have to do it right now.
You could
Well,
do that
if you-
right now, but you don't have to.
But if you do, then we don't have to continue the meeting.
Right.
Except for that Joe is looking for more to work with in a decision as to
Right.
things like the
So-
detention basin.
So here's where we need,
And
we
trail.
we will need that in writing. As Joe has suggested, and I'm sure, I suspect all of us on the board would agree that something, it doesn't have to be extensive, but something in writing, committing to work with the land trust to determine the best location for the basin, and to determine the best treatment for the trail where it currently gets muddy. And anything else that you want to put on record before we close? Rob?
Just a quick procedural question to benefit Joe potentially is, if they're going to work with the land trust, do you need something from the land trust saying that will work? I mean, do you want something in writing from
Well,
us? We have a board decision.
The form I'd look for is satisfactory to the board. In other words, they have to, in their definitive, they have to make arrangements that are satisfactory to the board.
With the planning board or the land trust
The
board?
planning board.
No, and
Okay.
in making a decision, whether it's satisfactory to us or not, we'd be hearing from everybody.
Okay, okay.
So-
Just if you need a letter from me, just
So
let me know.
my recommendation is that we're not looking for the engineered solution. We're looking for something codified in a document that then is put into the record as an exhibit that then can be referred to as a commitment associated with the flags.
Okay, because the Land Trust Board did vote to approve a land swap of equal
Right.
area.
So
Yeah,
the
now-
decision would likely be written that then, prior to the submission of a definitive, a concept plan is submitted, basically encapsulating these things to be determined consistent with the board's decision and blah, 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 but that's at the draftsman stage step. But that's sort of like how I envision that working, so that they're not doing the whole definitive and
Right,
letting the board provide that input before.
With what we're talking about here, it would be relevant if the land trust were to take the position that, no, we're not gonna talk with these guys.
Right, and that's why I was wondering if you wanted something in writing at this stage so that I
Other than
can't just
that-
change my mind later.
Sure. So what we've been suggesting is that they're gonna make a commitment to work with you.
Yeah.
And unless you have an objection to that right now, what we're suggesting they write is sufficient.
Okay.
We
Yeah,
don't need
I just want to make sure if you need something from us, I don't want to be the bottleneck for something.
And Joe, it's not, to me, it's not just submission of a plan, it's satisfactory to the board.
Yeah,
In
no,
other
that would
words,
be-
the board has to be happy with it.
Yep.
Now, with all that, given that we have some pieces of information that we strongly desire to get on the record, that implies that we need to keep the hearing open
Until the next meeting.
until the next meeting. And that would give us the opportunity to receive that information. I'm assuming that no other, and plus we can, of course, receive any other information anybody cares to submit for the record. But that's, at this point, those are the only loose ends that we've identified. Assuming that takes care of it, then we receive those documents, we can close the hearing and work on a decision.
Okay, so nothing from me then.
This is not a question of you. I do have a question for the applicant. Is the proposed driveway cut marked on the ground?
So there's an existing access where this intersection would be. There's a gate here, so it's
There's a gate, so-
visibly evident that where that road
Okay,
is.
because then if we go and visit and I want to see the sight lines and I want to see the distance from the intersection and I want to really go to the ground, there is a way to know where that is. And it's the gated, there's something there.
Yep, and it's also the first break in the stone wall as you come up from the land trust parking area.
Can you, on that drawing, blow it up some and then show me where the wall is on both sides? It's hard, okay, I see it. Okay, it's pretty much right at your,
Egress point.
the middle of your right
Yeah,
of way.
pretty much the right side of that stone would be the center line of that subdivision road.
Oh, show me, the right, as we okay, so if we stand at the uphill stone wall end, we'll be in the middle of the road.
Yep.
Okay,
Okay.
thank you.
So we seem to be suggesting a continuation to September 23rd.
To ask Joe if we wanted to, is it premature to suggest we have a draft decision ready for the close of the hearing on 23rd?
Absolutely, I cannot get that done.
That's no way in 2 weeks with the available resources.
Remember, we're shorthanded still, right? You're still shorthanded.
Yes, yeah,
you
we're
know.
just starting interviews.
So there's a conflict in availability with the McGriffs. They wouldn't be able to attend that meeting. Is it possible? I don't want to further delay this, but to the following meeting after that.
Yeah, if-
That'd be the 7th.
October
yes,
7th.
If it's acceptable to you, we can live with that.
Yes.
That's no problem.
Yes, if you don't mind another 2 weeks in the process.
My only comment is we still need the preference of the flexible thing on record.
he knows that.
Yep. Just repeating.
Yes, we don't wait for the public hearing to receive that.
And if you get that stuff in, now, then in case there's a problem with any of it being in time, there's time to, don't wait until the last week of that 4 weeks.
Well, that needs to be within 7 days.
Well, the response
Tonight.
does, but
The other items.
Oh, in the bylaw, there is no penalty if all of a sudden we received it on 8 days. How do you enforce it?
Non-existent. No. It says, nope. I don't think that's ever come up, Joe. No, I what to call a meeting on the 7th day and,
Right, everything's off, it's all gone. They didn't respond.
Well,
didn't
are
see.
we there then? Oh,
Well-
well, we have to accept,
we
they have
need the
to.
request.
If we
Yeah.
were to get a written request from the applicant to continue the hearing to October 7th, we could then vote to grant said request.
Do we, are these to be kept?
I think,
Yeah, you can line
Oh,
Seeing as how the applicant appears to be in the
Just something
process
I've
of
always
writing
wanted
said
to do.
request,
Because,
a
in
motion to
fact,
grant
this
said
isn't even-
request would be in order.
I move that we grant the applicant's written request to continue the hearing until October 7th at 7:30 PM.
here's the current.
Moved and seconded.
Oh, well.
Any discussion?
Probably seconded.
Hearing no discussion, all in favor?
Aye.
Opposed? Declare that motion carried
Oh, we're only
unanimously.
10 minutes over. Darn, it
And-
wasn't even worth my motion.
Not too bad for time. We had no bills to be circulated. Do we have anything in the way of
26
a
sheets
staff
of
report that
Mylar
we need?
stuff.
Oh, yeah.
That's
And-
like gonna be 11 o'clock.
That's after the vote to
that's
adjourn.
gonna happen after agenda item number 8, which is not debatable.
Any staff
Actually, we
reports?
didn't get a staff report.
Do we have anything you want to give us for a staff report, Joe?
Outside of running around like a chicken with my head cut off, trying to manage all the material coming in for these public hearings and meetings. One of the it is hard to believe that we just met 2 weeks ago. It feels like it was actually yesterday. I'm trying to pull together the findings for Brigati Village. That's one of the main things that I'm working on. That's a lot of material and going through to try to codify the bylaw findings and start tying things together. The hope is to start on the 23rd. Start going over some of those. Majority of the applications that we're dealing with, as long as now with Crown Castle that it is short, as long as they can get that in. The others applications that we have are basically minor. Estherbrook, it's a 1-year extension for the 2 phases, as well as a small change for a battery storage pad. And then we'll also have a application for a special permit for a sign at the Grafton Inn. So the applications are rather minor, as long as we can dispense of them quickly so that we can then focus in on starting to deal with the specific issues with Brigati Village. Still ends up being a lot of work trying to finalize and coordinate a training within the next couple of weeks for Viewpoint for staff so we can start actively implementing that. We're dealing with I have Affordable Housing Trust coming up next, not next Wednesday, the following Wednesday. There's a couple sites that may be proposed as far as trying to see if they may be interested in acquiring those parcels. And assisting the ZBA in project oversight you may have noticed on Wheeler Road. They're actively starting construction at Elm Rock. They have the drainage basin installed and graded out. Now they're starting work on actually the subdivision roadway. So assisting them finalize their process, and also starting with assisting them on, we got a request for determining High Point being complete. Because the planning board's the only one that goes through that process, I'm participating with them to act as a resource as far as how they should handle that. So it's a lot of busy work on some of these small things. Oh, and also making sure with the Board of Selectmen office warrant as far as the public acceptance of DeRoche's Landing, making sure that that's all set. And also, we're coming up, the end of the month is when the annual report for the town's stormwater report is due in. So the federal government and DEP, there's new MS4 permit. Reason why you see all of a sudden pet waste and other stormwater things is because there's required components for public education. Leah and myself are handling that component. The engineering component DPW is handling. So this last 2 weeks there's been a lot of activity on small things, but not any, say, large project. Still actually waiting for results from the DPW site investigator as far as whether or not there are any contamination issues with the DPW site, so that I can finalize a scope of work with Mass Development to retain a consultant to start that public planning process for the old DPW site. So.
Is there anything more needed for the library? I think we did what we're supposed to do for the library quite a while back.
Yes, they have, they're still working with some preliminary issues, trying to identify some things with Bob, but there are some remaining things that are on myself, as well as Conservation's punch list as far as before anything can start happening. Pre-construction meetings, making sure that all the documents and plans are recorded and distributed to town departments, erosion control being up and all those things. So there's some, what are really in the big scheme of things, minor things, but there are still some things that they need to handle administratively with staff before starting any sort of construction.
I noticed the selectmen voted to sign
sign a contract.
The contract.
Yeah.
And we expected to see shovels in the dirt, in the ground out there the next day.
Oh, if only, only contracts
Because
work that fast.
people are, you know, out there on the internet, people are they gonna make it? You know, they were delayed, are they gonna make it?
Not gonna make it.
If they don't, they'll, you know.
Yeah.
Do you know when they're thinking about they're going to actually start?
Few weeks.
No.
Based on the meeting today, they are still a few weeks away from groundbreaking, whatever.
Well, then I will have to remind them before they actually do the groundbreaking that there's things that they need to handle with planning and conservation first.
The reason that's interesting is, if they don't break ground until into November, first of all, they're gonna have a grand time doing that. And secondly, that would be great now that we've gotten this far, because then we have the parking place still. We have there's that festival.
Small
Small
Stones Festival of the Arts.
And one of the joys that's going to happen is there's not going to be much parking.
Yeah. Well, you know, they say this, you know, like 50 is, or 60 is the new 50 and 50 is the new 40. Well, November's the real new October.
Oh, okay.
So frost isn't in the ground as late in the year, so it's sort of like, you know, construction season is now expanding a little bit more.
Well, yeah, because some people have expressed concern that they not be pouring foundations in the wintertime, basically. There's something about the DPW I don't remember whether they did something in the ground in cold weather that caused a problem, but it was like it, they were saying it had. In any case,
Yeah, whatever.
anxious to see that
Yep.
getting out of the ground.
Yep.
Or getting into the ground and out of the ground.
All right, moving along if we can. Anything in correspondence that we needed to pay attention to?
No, not unless anyone had any questions. There's a correspondence that I included that had to deal with the inspections. There was a correspondence having to do with the Surface Transportation Board, which is really follow-up to a letter that was in last meeting's correspondence packet about a change in maintenance ownership or operational ownership for the Providence Worcester Railroad, encouraging working with communities. Everything else ended up really being public hearings with adjacent towns, if memory serves correctly.
Any reports from planning board representatives on town committees and CMRPC that we need to hear tonight?
I have one input. So today was my first meeting with the Library Planning and Building Committee. One thing I noted on Grafton News was some kind of talk around $1 million being found from the building committee that could be deployed for DPW. That apparently is not formalized. That's still an exploratory question by the town administrator, that is that a feasible option to look at that money being as a surplus, and can that be moved? So it's still nothing finalized. Based on what I thought I read on the Grafton News, it seemed to be all finalized, and that money was.
If what I saw, I think, was saying that they want to go to town meeting with an article that permits that transfer, and town meeting would decide whether to do it or not.
Right.
Or not the whole I don't think it's the whole million, but
Yes.
a big piece of it.
When I was there this past Tuesday for the select board meeting, they were basically saying that because the bid came in just over $1 million under what they were anticipating, they still have the 10% contingency on the overall project. But that if the select board is willing to file what was called a DE2 or DER2, I forget the exact abbreviation, that they can, that $1 million or whatever they exactly put into the warrant article could be still debt excluded money, because they're moving from one debt excluded thing to another, that, but they still have to file that with the state, and the state still has to approve it. But
It may not be the entire sum, it is.
Yeah,
I
but
think.
it still
I
has to
thought
go
town
through,
meeting-
but it still has to go through town meeting to move the money, period. Otherwise, it can't be moved.
Yeah, the DS, whatever form, is, I guess, getting permission to do it, and then town meeting has to still
Yeah.
do it.
The town meeting is what can approve moving the money, but the state has to approve
Yeah, they
being
do
able to call that excluded money from debt. Otherwise, it's still,
Yep.
That's only update, that it's still being discussed. It's not what WhatsApp or Facebook would state, it's all a done deal, it's not. That's all I had.
Well, is there any prospect that the building committee would object or take some position on the
They are still
transfer?
evaluating, so it seemed
Oh.
50-50. For the larger good of the town, it makes sense, but
Yeah, sure.
that's the way they were looking at it. Again, my first meeting.
Yeah,
I could
yeah,
be half
the-
right and half not.
Yeah, they said that the DPW had a 3% contingency, whereas the library has the customary 10% contingency. And I think there's probably less ledge under the library.
I didn't do it.
very likely less ledge.
Anything else?
That's, well, you ever walk around the land near there, it's a little wet.
Are there any other items which may lawfully come before the board?
I move we adjourn.
I second that.
Moved and seconded that this meeting be adjourned. All in favor?
Aye.
Opposed?
Second time, yes.
Now, we have,